have attached the relevant notice as well. Your
Very
Lordship.
well. Show cause notice is not urgent. You give it because you will have an adjudication order. All matters will be urgent in that case. Recovery proceedings have been initiated. Garnishing notice is issued. That is understandable as urgent. Show
Your
cause
Lordship,
notice
but
has
in
been
the
issued,
show
that
cause
is
notice
urgent.
itself, they are seeking to
Then
recover.
all the matters are urgent. I cannot upgrade all the matters. Sorry. You give it, it will appear in the list. Be taken up in due course. Show cause notice is no urgency. Show cause notice, you reply to it. You want to withdraw it. Yes. लिखे नहीं? Learned advocate appearing for the petitioner hands up a copy of a letter dated November 1, 2025, issued by written by the writ petitioner to him, and submits that the writ petitioner is no longer interested in pursuing with the writ petition. Full stop. Yes.
My lord, I am for the petitioner, my lord. I am appearing with Mr. Mukherjee and he is engaged in courtroom Agartala for a matter,
This
my
is
lord.
appearing for dismissal.
My lord,
My lord,
this matter tomorrow, my lord, he will appear. Your
So
lordship.
why not today? This is appearing for
He is,
dismissal because nobody appeared on the last occasion also. Today you are trying for time.
my lord, this matter
He is
possible.
Agartala court for a matter, my Agartala High Court.
Why? Why are you not ready? Who is the advocate on record?
Masterpiece, sir, my lord. This is a change brief actually, my lord. I am for the senior counsel Rajul Mukherjee.
लिखे दिन. An adjournment is prayed for. लिखे दिन. None appears for the parties. Full stop. None appeared on November 7, 20.
Well, I am from
Yes. What are your instructions?
well, the instruction is that in this writ petition, my learned friend challenge my lord notification 56 also. Whether he will prayer my lord, kindly prayer he can seize my lord. He challenged the notification 56 of the central tax, where my Supreme Court matter is.
I'm not going into that. I'll not press that. I'm just
Please
pressing
don't
the order,
press
my
it.
lord. So
Well, then other is otherwise.
Yes, because order is otherwise.
Judicial order.
लिखे नहीं. At the outset, comma, learned advocate appearing for the petitioner submits that he is not pressing prayer D, prayer C of the writ petition, whereby the writ petitioner has sought quashment of notification number 56 of 2023 hyphen central tax dated December 28, 2023, issued by the respondent number 1. Full stop. Paragraph. This writ petition assails an order dated. Where is the order?
My lords. Order is at page number 43, my lords. Starts at 43, my lords.
Order dated August 31, 2020.
Joint Commissioner, my lords. Respondent number 2. No, my
My
lords.
lords, CGST, my lords.
CGST, Kolkata North Commission.
My lord.
73, my lords.
73, my lord.
Yes.
Hi.
11 December 2020, my lords, page number 116. The order starts. Page 122, my lords. My lord. Notice was issued on 30th of May 2024, my lords. Page number page 36, my lords. Yes, ma'am. 2017-18 melts.
Well,
It
31st
is
April you will
1920. 1920. Yes. Nineteen twenty. My lords, Kashmir power. Yes, my lord. I have it. My lords, kindly takes my compilation, my lords. Starts at page 219, my lords. My lords. Where his lordship's Justice Sabyasachi Bhattacharya. Page 228, my lords. Two to eight, my lords. They've discussed section 53, and at page 230, it has been held that in liquidation transfer of liabilities is not automatic. Para 64 which my lords was alluding to. Nineteen
1920.
Lordship. Cancellation.
Initiation, the legal heir or the representative. Issued by
Information regarding death was given, Your Lordship.
my lord, prior issuance of the show cause
You
notice.
don't inform them about the death
My lord, I
prior
have
to the
informed.
initiation of the proceeding.
My lord, I have informed, my lord. Prior initiation of section
Initiation-
73, my lord.
See, your notice, reply to notice is 6th of July
My lord,
2020.
that is, my lord, immediate after that, my lord, I have been advised that I cannot reply, my lord, and that initiation, my lord, not the adjudication proceeding, my lord, this is the written scrutiny, my lord. I replied to the written scrutiny. I have been advised by my consultant that I cannot reply as a legal heir. Immediately after that, my lord, I uploaded the
I
cancellation.
can't get you. In the while you are replying to it, you cannot inform them that no, please don't give
My
me
lord,
this notice. He has
That
died.
is why,
You
my
can
lord,
definitely
immediate
say
after that, my lord, I have applied through the
No, fine,
statute.
immediately thereafter. In
Yes, my lord.
response to the notice only, you will say that why are you issuing this notice to me?
My
He's
lord,
dead.
it was uploaded, my lord. My lord, I bow down by your
So
lordship's
that is
judgment.
because,
My lord, but
you
this is
cannot
not
take
the
them by
proceeding, my lord.
surprise suddenly. You have made them to believe. Come to page 50.
My lord, kindly consider, my lord, I am not challenging that procedure, my lord. The proceeding of adjudication has been initiated after that, my lord. That is under the challenge, my lord. That is page 58, my lord. Show cause notice, my lord. The show cause notice has been initiated after having the information about the death of the proprietor, my lord, and immediate after, my lord.
Yes,
My lord, I am challenging the
Mr.
adjudication
Chakravarti,
procedure.
there are two proceedings. One proceeding can be sustained because in that proceeding she participated without informing you that she has the sole proprietor had died. Now, after informing, after the information being given to you, you again issue a show cause notice in the name of the dead person. How can the second one be sustained?
Well, that was in the register, that was in respect of the cancellation of the registration.
No,
No, my lord.
this
Yes,
page
one.
58 is not in respect of cancellation.
My lord, what I have asked the officer, the same query. My lord, first, my lord wanted to know page 57. My lord wanted to know from me why it is the first line it says
Yes.
satisfactory.
My lord, that I have also,
Agree.
my lord, that I also have checked.
Well,
my
that
lord,
is the
from my lord.
form. That is the form. That is the difficulty. I'll show Ari.
No, my lord, that is also, I am admitting, my lord, I also have clarified from my client, my lord. The petitioner was not aware, he was under bona fide belief since the
The
death of
registration-
has been intimated, the RC will automatically cancel, my lord. So, my lord, the question of submitting any reply or subsequent show cause notice does not arise at all when I am
You should
filing.
not have submitted reply because if you submit reply in the
Yes,
reply,
my-
I have gone through the reply.
Yes, my lord.
The reply is on merits.
Yes, my lord.
Reply does not say that the
My lord,
proprietor
that
has
is why,
died.
my lord, even after, my lord, when I have submitted the application for cancellation of registration, my lord, on the ground of death of sole proprietor, my lord, thereafter, if any show cause notice also has been issued, my lord, I am not aware, my lord. And my lord, kindly consider that if the show cause notice has been issued, my lord, they
See,
have,
first proceeding,
Yes, my lord.
I have difficulty,
my
you
lord.
cannot
And
come.
my lord, there is no
But-
demand against the first proceeding. That is why I am challenging the second subsequent
This
proceeding.
proceeding, Mr. Chakravarti, the proceeding which has been initiated by issuance of the notice dated August 25, 2022, page 58. How can this be sustained? Because by this time you had knowledge. How did you inform before this? Where is that information?
My lord, that is the, my lord, information is at page 55, my lord. This is I apologize, my lord. Today I could not take printout of the entire application, my lord. I have downloaded. This is the application, my lord, acknowledgement of the application of cancellation, my lord, where I have intimated on date of filing, my lord.
What is the application? In the application, you have given the reason.
Yes,
that he
my
is
lord,
dead.
my lord. My lord, if your lordship kindly allow me a 1 day's accommodation, my lord, I shall
No,
bring
it's a
out
fact,
all the
my lord. I have
documents.
also, my lord, because I have taken instruction, specific instruction. His application for cancellation of registration was on the ground that the concerned person has expired. I admitted to. But it is not there, I could not find. But I have got the specific instruction. Let us, but I'll give 4 dates. What is the difficulty? First, there were discrepancies, whatever, but there was no scrutiny. I issue SAMT 10. That is dated 22nd June 2022. Page 41.
Page 41.
Yes.
Yes.
And can we see who is the officer? Difficulty, the 2 officers were dealing with this situation. So when the cancellation of registration was done in a different officer, so he did not have any access.
But that for that
Man.
the
I understand that is,
cannot be faulted
but-
because
but-
department is one. You may have different
I know, man,
divisions
but-
inside.
but SAMT 10 he replies without mentioning that the concerned person has expired.
Yes,
On
that I put
and
to her.
that ultimately results into the DRC 01. That is the show cause notice. So once SAMT 11 is the basis on which, after considering his reply, the show cause was issued. It is a continuous manner because section on the previous occasion, my lord was shown those judgments where section 61 is started. I have to proceed with section 61. So this is a case, classic case, where the section 61 started from SAMT 10.
No, but Mr. Chakravarti at page 23, was not this the order then?
Yes, my lord. It is a subsequent order, my
It is
lord.
a subsequent
Final
order.
order, my lord.
My lord,
My lord,
this
how
is
I come to
different.
know?
This is something different. 23. My lord, this is the result. My lord, SAMT 10 started SMT 11 he replied to, then the show cause notice, then
Matlab, how-
he chose not to reply, whatever, he or whoever was concerned, and thereafter the order passed.
My lord,
This
how
change-
would I know that our show cause notice after,
Well,
even
this-
after filing my application for cancellation, prior cancellation
But
on the ground
Well,
of death of sole
these two
proprietor?
proceedings are separate and
Yes, my lord, that is why I am.
separate. My lord, once
You file a short report in the form of
My lord, I'll
affidavit
file.
because facts are very clumsy, very.
And my lord, it is a well settled
And
proposition,
madam,
my
you
lord.
also file a
Yes, my
supplementary, bring that application.
My
on
lord,
record
and my lord, it
because
is a
nothing
well
is
settled
there.
proposition, my lord. The proceeding against a dead person, my lord, I am not standing in the way that tomorrow if department is coming and issuing a notice in the name of the legal heir, I cannot stand in the way, my lord. But these two
You
notices
bring it
cannot
so that
succeed.
an order
Yes,
can be passed regularizing
My
the
lord.
entire thing because this way it cannot, half of it is dead, half is alive.
My lord,
It makes no sense.
But
My lord, is
at
the-
the SMT stage, if my lord landed
You bring that
yes,
chronologically.
but I have that chronology is there.
my lord, how would I know, my lord, that the same officer we are different, my lord?
SMT,
Officer issuing.
You made the problem, you
My lord,
created
below
the
postal
problem by
ballot.
replying on merit.
Yes, my
Your,
lord, that is
your
admitted
answer
fact, my
was
lord.
he's dead.
Yes, my
That
lord.
would have
My
solved the
lord, that
problem.
would have, my lord.
You replied on merit.
My
You
lord, but-
invited them to pass the order.
But my lord,
They have passed the order.
no, my
Now
lord,
you
they
say
have
the
not
order.
passed, my lord. That is, my lord, they have not passed the order.
Yes, it is passed.
My lord, against that ASMT 10, nothing has been passed, my lord. They have initiated a show cause notice, my lord.
ASMT
not
10 will, ASMT 10 is only for the purpose of
My lord, that is what I am submitting, my lord.
extracting the
Yes, my lord.
reply from
My lord, the
that
immediate,
they have got. After the reply, they are not satisfied. So
Yes,
they
my
issue a
lord.
show cause notice.
I
and then
admitted,
that
my lord.
culminates into
But,
an order.
but my lord, the issue is that, my lord, they could have also checked, my lord, from the reply itself. My lord, who is submitting the reply, my lord, signing the reply, my lord?
That's difficult. But for
My
who?
lord, the officer who has,
You
my lord,
have-
legal heirs, my lord.
You have kept the trade name alive.
Yes, my lord. I have not kept the trade name,
Yes,
my lord.
that
My
is-
lord, immediate
You are
after
writing
reply.
for
Yes,
such
sir.
and such.
Yes, my lord. But
So-
immediately after that, my lord, I have
You have kept alive.
filed the
That's
statutory
a
form
given.
for
My
it.
lord would find the chronology of events, date of registration, if my lord would sees cancellation for non-filing of it.
My lord,
Now-
that is because, my lord, they have
Please,
cancelled my,
please.
yes, my lord. I may have also a copy so that I can assist. I am giving you.
So the cancellation is subsequent to the order.
No, that is filing of
My
non-filing
lord,
of
this
the
is,
return.
my lord,
Another
That is
separate.
different.
all different, my lord.
ASMT 10 is issued in respect of 61 proceedings.
Yes,
Yes, ma'am.
that is where that, my lord would, that is the proceeding. If she replies on merit, the concerned person, then my lord section 73 invoke. So the chain of events,
My lord,
my lord,
does
kind of
all 61
my
proceedings.
lord, that is my lord, section 61, my lord knows those judgments were shown.
Not yet knows in the process.
No,
of
no,
making.
those judgments were shown. When once the section 61 has started, it has to, when I am satisfied, or if I am not satisfied, I will issue a show cause. And that is being done.
But this ultimately it will lead us nowhere.
Nowhere.
Wha-
My lord,
where
I
to-
would rely on 93.2. If my lord see the subsection 93.2, I was seeing, my lord. (93)(b), my lord, sorry, subsection 1B. If the business carried on by the person is discontinued, whether before or after his death, his legal representative shall be liable to pay
But
out
then
of the estate.
Then the notice has to be issued in
Yes,
the name of
ma'am.
the legal.
It
entity.
has to be, my lord, it has to be.
Notice has been
But
issued
my
in
lord,
the
there
name
has
of
to
the
be a
petitioner.
crystallized, my lord, whatever the liability, my lord, the difficulty is today, how we'll crystallize the liability. Because this death, whatever has occurred during the lifetime of the concerned person, of that tenure,
No, my lord, this is a prior period assessment.
89, তাই তো
89, no,
when
my
he
lord.
was alive,
He was alive,
Yes.
yes.
when he was alive, that is
The tax cannot be avoided,
avoided.
but the realization will be only in
My
respect
lord,
of
the
the estate,
realization has to be
from the estate,
My
from the estate,
Estate.
unless the business is continued.
unless
Yes,
the
ma'am.
Now,
business is
the problem here is again,
the
the
business.
problem, business continued till a particular period
Yes,
of
my lord,
time.
that is the difficulty, my lord.
When the proceedings were initiated, at
Business was not
yes,
continuing.
madam, you sought for cancellation of your registration when? 2022.
My lord, the business was not continuing, my lord. My lord,
Your
that is,
reply doesn't say so, madam. I have gone through your reply.
my lord,
This reply, your
my
reply
lord, that,
doesn't say we have
my
stopped
lord, that
business.
for particular, my lord, my reply was restricted for that particular period, my lord.
That can't help. That is on fact.
My lord, wait,
It will be in
yes,
any case a separate wrestle.
my lord,
File
because, my
a
lord, that-
reply, my lord, we'll file a report.
You
my
will
lord.
my lord,
file a report because
my lord,
it's
because,
very
my lord, I have already surrendered my trade license also, my lord. These were already uploaded.
when did you surrender?
My lord, I shall also bring all those documents, my
When-
lord.
We'll let him
Yes,
file within 1 week. Thereafter, we'll file our report.
My
Or else, my lord, without
The petitioner seeks time to file supplementary affidavit bringing on record the application where not restrain them.
my lord, they have, my lord, having all these documents, my lord, they rejected my application for cancellation, my
The
lord.
damage was done because of the reply on merit.
My lord, but my lord, my humble submission is that they also should not have cancelled my application for RC.
Right,
Madam.
that's-
By that time, they would have also get hold my estates, my lord. Grateful, your lordship. No, it's there. You go and get.
My lord, on the last occasion, the respondents had sought for time to take instructions in the
Yes,
matter.
Mr. Bhattacharya.
My lord, I have taken, my lord, written instruction. Now, my lord, SSC's case is that, my lord, he is holding 2 mills. Now, my lord, he says, my lord, the SSC says, my lord, one of his mills, my lord, the notice has not been given. And
No, the contention of the writ petitioner is that the mail in which notices were sent was actually owned by the petitioner's consultant.
yes,
And there was one mail which the petitioner had, to which you issued the last notice pursuant to which they came to know about the proceeding.
now, my lord, I have taken instruction, my lord, in the return filed by the SSC, altogether, my lord, from 2013-14 to 2021-22, the mail email address is agcontit@gmail.com. In that mail, we have served the notice, and this is my written instruction, and this is the first pages of returns.
So two of them are registered, one through email and one on the portal.
Yes.
I have one while filing the returns and one on the portal. I'm doing this. I'll pass an order directing this order to remain in abeyance. They will file their reply. If you consider the reply convincing, then you will pass a fresh order, or otherwise this order will remain effective.
Because, my lord, the department was aware of my email ID as well.
Yes, but actually you cannot fault the department also, because in the return that you had filed under section 139(1),
Yes, your lordship.
there
We are
that email ID was there, so they are entitled to give it at that email ID
absolutely,
also.
my lord. We are not disputing
So-
the
so
validity of the
therefore, I'm not putting
service.
aside the order. I'm putting it in abeyance. The order shall be kept in abeyance. You will be given an opportunity to file your reply, respond to it. They will consider it, and if they reach a different conclusion, they will drop the proceeding. Otherwise, the order will remain
I'm
effective.
grateful. We also have the point that the approval was
Supreme Court. Only
Now,
seven except
the
seven except
says
it seven ex
better. I know Mr. Mujumdar knows better than me, but
No.
Mujumdar
I
corrected
never-
hexaware, the main matter pending before the Supreme Court. There is no stay, formal issuance of notice. Now, I have a judgment of the Honorable Supreme Court. It says that the jurisdictional department is bound by the order passed by the division bench. In our division bench, order passed by the Honorable Chief Justice, the department is bound by. I will place next matter. I will place the judgment. It is not that
subject to correction, but subsequently that order has been recalled. Our division bench also passed in favor of the assessee. I think my learned friend is when subsequent the recent order passed by our Chief Justice in favor of the assessee. I think
have that order?
yes, I have that forward. Should have been this. Keshuram copy টা কোথায়? Keshuram Industries by. They are bringing the copy of the. I'm giving you within 2 minutes.
Yes, yes.
The আছে তোমার কাছে? Yes. আচ্ছা, my landed phone is carrying. Bill. This is sorry. কোনটা? Keshuram Industries. The copy আমার Rajasthan High Court judgment. Hmm.
It's not clear what was
Not
not clear as
Not
to
clear.
what was.
No, this is Rajasthan High Court, the recent judgment passed, but detailed judgment has been passed.
Now, your lordship, kindly.
And my lord, my third point before your lordship, this is mandatory on the part of the adjudicating authority, serve the approval. And he has passed the 148 AD. It is a consequential that approval has to be given. The subjective satisfaction has to be supplied to the SSC. And in this regard, my lord, I can, my lord,
My lord, I am not denying. My lord, I have said before your lordship, my lord, the
My lord,
approval point, my lord, I have missed out.
my lord,
I am not said, my lord, the approval not required to given. I am not said
this
that.
is, my lord,
But there is
the
no
Supreme Court
requirement of
judgment.
judgment because, my lord, I am not denying that. Look, it's settled in
No,
the
our-
rule of law. I am not
But
denying.
our
not
High
denying.
Court, after following this
My lord,
clear judgment,
my
Supreme
Mr.
Court,
Mujumdar submitting, my lord, I am submitting, I am agree with him. My lord, why is showing the judgment? I do not know.
man, it is my duty as an
I am
officer of the
I am
court
also saying
to
that this is the
apprise the court what
position
is
of
the.
law. I am not denying that.
Very well. So you will come tomorrow then?
My lord, more.
Come tomorrow.
Yes, your lordship.
Come with the instruction then.
Well, otherwise
So
also
that I
3 point
can
raised, but interim order, I am praying for interim order also, man.
My lord, if
My
my
lord,
lord,
my lord,
better-
I'll
well,
finish it.
my lord,
these
if
three
it's
issues
better,
are
my lord,
there,
learned
three
friend
issues are there, almost settled.
goes to the department again, it is better for also him.
My better.
So should I then set aside and send him back for hearing?
Yes, my lord.
Better then, because
Better.
natural justice is there. So,
Great.
uh, this writ petition is directed against an order
to my lord my lord, the 148 notice issued by the my lord, judicial assessing officer and not by the faceless manner, according to my learned friend. Now, my lord, there are two views of my lord, different high courts. Now, my lord, as per my knowledge, my lord, this is the judgment passed by the different high courts. My lord, I am placing before your lordship for lordship
No,
consideration.
just place the division bench of our high court.
My lord,
Other high courts, I
division
don't,
bench
I
of
know,
our
I am
high
aware.
Dhanbridhi follows me the TK Builders of my lord, Delhi High Court Division Bench. And my lord, from paragraph number 5 of the judgment, my lord, the my lord, reasoning has been given by this honorable court.
So interim order was not granted.
No, yes.
So
Now, my lord,
Order, my lord.
I will admit the writ petition, but I will not grant interim order.
My lord, kindly grant me, because I am submitting the next order passed by this court.
my lord, now my lord, may
I do not know whether this order was brought to the notice of the court
Yes.
or not.
This was considered.
Dhanbridhi was brought to the notice. Show me.
Kindly see this order.
my lord, this order, my lord, that is my lord, the
This order, kindly see.
Mr. Mujumdar, my lord, placed this order.
Kindly see this order. And the second page, last paragraph.
It is not clear
is
what
not
was
clear.
the issue involved. Whether faceless and jurisdictional officers issue was involved or not is not
Only
clear in the
140
order.
issue involved.
My lord, here 140.8 issue was involved. My lord, because since
148 is everywhere. Wherever there is reopening, there is 148. But whether 151A was involved or not, or whether the jurisdictional issue and jurisdictional assessing officer and faceless assessing
Kindly-
officer
kind-
issue was
kindly-
involved or not is not clear.
kindly come to page last paragraph of page 2, my lord. The
Page
learned
2
senior
last
report-
paragraph, yes.
learned senior report for respondents places lands on the order passed with this court and Dhonbridhi services, while prayer for stay was rejected, but appeal was kept pending for the reasons. But what was that matter, my lord? Dhonbridhi, it was 148. Now, my lord, wherein the prayer for stay was rejected, but the appeal was kept pending for the reasons assigned in this order. Thus, effect to the recent decision of the order of Supreme Court affirming the order of the High Court of Bombay and the High Court of Telangana have to be considered in this appeal.
No, but
no,
these orders affirming the orders of Bombay and Telangana have been recalled, is what I was told by the Honorable Supreme Court in a recalling application. Honorable Supreme Court's order affirming.
I have given, my lord, on the last occasion I have.
Please let me complete, then only you will be able to understand what I am saying. These orders, I was just now told, that have been recalled by the Honorable Supreme Court in a recalling application, and matters have been kept for hearing again. So these orders are not there, which were there before the Honorable Division Bench earlier.
Then, my lord, hexaware stands.
Hexawares is not binding on.
Now,
Hexaware is not binding on.
Hexaware will not stand. Your lordship kindly see this chapter of honorable Supreme.
My lord, this order I was placing, my lord, here also 140 notice was involved.
148 will be involved everywhere. That doesn't make
challenging the notice under section
Corrigendum,
140 Act
corrigendum,
previously.
That I know, not required. Settled, well settled.
Yes, my lord, therefore, my lord, and after in this order, my lord, that that order of Dhonbridhi was considered and stay was granted.
No, but these orders of this stay was granted because the Honorable Division Bench found that Honorable Supreme Court had affirmed the orders of Bombay and Telangana. What had happened to those orders? Mr. Mojumdar just now submitted those were recalled.
Recalling application has been filed, order has been recalled because
You have those orders.
What is
Bring those orders so that I can distinguish this and then we can have a line in which we can proceed. Can you bring them tomorrow?
My lord, latest statement of the Rajasthan High Court, my lord.
Rajasthan and Bombay are not going to bind me.
Well,
I am bound by
only-
my division bench.
only Milord point is that Milord whether the hexaware Milord admitted by the Supreme Court any stay has been granted, then in that case only Milord stay be given, and not on any other case. Milord hexaware or any other judgment of any high
My
court.
lord, where my lord settled law is that, my lord, that if an SLP is admitted and the lower court's order is under jeopardy, if that be the position, my lord, can that be taken as
But the answer
and
Milord, I-
proceeded on the basis
but
that
I
it is
have-
not stay has
but I
not been
have-
granted.
Yes,
Therefore,
yes.
Yeah,
We
I-
have an example here only. When those notices were being challenged on the ground of limitation, our court heard it while SLPs were pending and stay had been granted. What was the matter? I am forgetting the name. Bansal's case. When the Bansal's case was pending before Supreme Court, matters were being heard over here. I was also a part of it.
Arti one.
my lord, in my own case, stay has been granted. I have given that order.
Granted without considering Dhanvriddhi.
My lord,
If there is a division bench which has decided a matter in a particular way, how can I ignore this?
my lord, kindly see in my own case, the orders were.
You have given that in your own case. You have given that there.
Yes.
Dhanvriddhi
And
was not
relying
placed.
on division bench order of this court. And
That
that has
was
not been-
not placed. This is recent.
And recent order also stay has been granted, my lord. I respect to
Recent
some.
order stay has been granted on the basis of Supreme Court judgments, which has been stated to me to have been recalled. I will record all of this. If the Supreme Court's order is there, I will grant stay. If it is not there, I'll give my reasons.
No, I have given one order, my lord. Telangana High Court's order was Supreme Court's order was also given, my lord.
That has been stated to be recalled subsequently.
That I have not known.
That is what I'm saying. That is why I'm asking him to bring. Just now a submission was made, just the earlier matter. Mr. Mojumdar made that submission.
Yes.
Then, if the order is not there on that basis, I will grant stay. Doesn't make sense at all. You see if it has been. If it has not been recalled, I'm bound by it. If it has been recalled, then there is no order. You get my point?
Yes.
Yes. लिखे नहीं? Affidavit of service filed to DBK.
But very short matter. Proceedings for short payment of tax, my lord, 61 scrutiny done, 73 done. I went up on appeal before the appellate authority under 107. There was a delay of 120 days.
How
Now,
have you explained the delay?
my lord, the delay was majorly explained on the ground that I did not have the money at that point of time. It took me some time to get that money for the pre-deposit. So that now there's one twist to this. So when I filed my appeal, and admittedly, so I'm not going to go here and there was no Section 5 application. They show caused me. When they show caused me, then I filed my condonation of delay application, and there I took this ground. In the impugned order, I think on this particular ground, the reasoning is perfunctory. It is not properly reasoned. But be that as it may, I am really seeking my lord to
Where is
exercise
your
discretion.
application for, I mean, your
Yes, condonation
explanation
of
to the
delay, my lord. Condonation of delay is at page 137. At page 138, the reason is mentioned. Partners were changing, names were changing, and we did not have that fund. All these three reasons have been given. At 138, second paragraph, underlined and highlighted part. Now, if my lord comes to the
Yes.
Now, if my lord comes to the impugned order, which is at page 191, continues over to 192.
What are all these medical documents? What are these?
My lord, these weren't placed at that point of time with the condonation of delay application. These are here in the writ application because the client now have advised us that his wife was also sick, but that was not there before the condonation of delay. So I cannot take that one. I'm not even bothering my lord with that. It's really page 192. My lord sees the reasoning is possibly perfunctory and cannot be countenanced because there are three grounds taken, and those grounds have to be sufficiently dispensed with reasons. My lord sees second last paragraph. Whereas the appellant has failed to submit any reply citing sufficient cause against the aforesaid late submission of appeal by more than 5 months. That's all that he says. This is not good enough reason. But discretionary jurisdiction kindly allows me.
It's a, I believe it's a partnership from whatever Manoj had condoned after imposing cost. 5 months.
But I was hoping that this error on their part for lack of reasoning would help me mitigate the cost
I
amount.
can send you back to them for reconsideration of your delay condonation application.
My lord condones the delay here, kindly.
They will reconsider the application for condonation of delay and pass the reason
My lord will condone it here and now.
on merits.
No, my lord will condone it here and now, kindly.
Finish. The petitioner is aggrieved by an order
My lordship, I am for the petitioner seeking adjournment. On seeking adjournment, my lord, I am led by Miss Anupa Banerjee due to her daughter's medical condition. He is not available. She is not available today.
When do you want?
Any date in the next week, my lord? Any date in the next week?
An adjournment is prayed for on behalf of the petitioner.
Uh,
This matter, but this was
No, this is, my lord, my writ application challenging a proceeding which has been undertaken and culminated into an order passed under section 148 capital A, whereby there'd be a grant of sanction eventually for reopening the assessment. But my ground is very limited, very short point which is involved in the dispute, my lord. That is that the assessment year, which is the subject matter of the reassessment, is 1718. Under 148, 149, read with 148A, the period of limitation for reopening the reassessment, my lord, is 3 years. So that came to an end virtually in 2021. There is an exception which is carved out under section 149, which is that if the total assessment reassessed value or whatever value, my lord, has escaped income tax, that if it's above the amount of rupees 50 lakhs, then that limitation gets extended. So they take benefit of that assessment, that particular exception, and they reopen. Now the difficulty with this is this, my lord, that today they issued a section 148A notice, a show cause notice. I replied to that show cause notice on the portal because this is faceless, whereby I say that you give me an extension of time till the 10th of July. I'm sorry, 10th of April, because the person who was dealing with my accounts, my lord, the accountant of my company, that person is unavailable. Within, my lord, a day's time or 2 days' time, my lord, they issue another show cause notice whereby they say that you have to file a response by 31st of March. I asked for 10th of April, they say 31st of March. I am unable.
being time barred.
That is the principal claim that I have, but I'll just give a little brief overview of whatever happened, because now the reassessment has opened. I would ideally, my lord, want similar, my lord, orders that have been passed by your lordship in previous cases. I would want the proceeding to, my lord, either way be kept at abeyance so that today my 148A application, my lord, can be heard out. I want an opportunity of representation. Now that opportunity has been closed. So 148A notice, show cause notice, I give a reply asking for extension of time. They don't give me an extension. They issue another notice saying you have to give it by 31st.
Mr. Dudhoria, why was the extension refused?
Yes, yes.
Everything was issued. In one, their reply was also considered, but they have filed a reply.
No, this is post sanction.
But what I think what they are saying was that that the order was passed by the jurisdiction officer. That point was not taken, although the 140 notice was issued by the jurisdiction officer. But the proceedings which humbly submitted, everything was done, but they have participated. 140 was there. Thereafter, 142 one notice was also issued. They have participated. Let the assessment will go on, because this is the order which was passed by the earlier court. I'm just handing over to your lordship. Although the
একটা copy তো। No, this is distinguishable. This is not what my case is.
But this is not, his case is not of a jurisdictional or faceless order being passed. He is on natural justice.
Lord, may I take, my lord, one more minute?
Regularly participated, 141, 221,
Yes, where is your prayer for adjournment? Show me.
My lord, I'll show prayer for adjournment is there. They've granted that also. May I just indicate one thing? My lord, possibly, my lord, I have not been able to make myself clear. But there are three stages of the reassessment proceeding. One is 148A, whereby whether the case at all can be reopened or not, that is decided. Now, once an order is passed under 148A saying that reassessment can be opened, then there is a order under 151 for sanction. Once the order under 151 comes, then there is an order under 148 saying now reassessment has started, you give show cause. Now
148 no order is passed. 148 is
the notice. So 148 notice. Now 140
all orders are passed under 148A.
A, whether reassessment can be opened or not.
Earlier it was ABCD.
That's right. Now, my lord, ABCD is there. My order is passed under D. The order, my lord, is passed under D. The difficulty is this.
Earlier. It is 3.
3, my lord. I am saying that 148 proceeding could not have been commenced against me. My case is that the sanction, there are twofold case. Number
148 could not have been commenced. This point ought to have been taken by you in the 148 AD.
Show cause notice.
Yes.
Show cause notice.
Yes.
That I could not, because they closed that opportunity.
So you take this point before them.
I am willing to, but
Yes, before the assessing officer,
this
148 is it has already been reopened. Now, once it has been reopened, when was the 148 order passed? That
148A order, my lord, is passed, which is at page number
AD order was
32.
AD
Page
order
number
was passed
32.
on 7th of April 2024.
That's right,
So
my lord.
you ought to have challenged it then only. Why have you come on 2025?
There has been a
148.
There's been a delay. There has naturally been a delay. I will not shy away from that. But there is another question to this. The sanction under 151 comes prior to, my lord, the 148 order.
Where?
That cannot happen.
How
The
do I
lordship
get
looks
that?
at page number 37.
Yes, page 37.
Page number 37. My lord, this order is passed on 6th of April. 148A order comes on 7th of April. And they rely upon a draft order under 148A. But that is beyond the scope of the IT Act also.
Why not? Why beyond the scope of
My lord,
the
the 151 or 148A does not, my lord.
148A is not requiring any sanction.
148 and 151.
Yes, sanction is required for 148 notice.
So
148 is subsequent to 148A stage.
Yes, my lord.
So 148A stage they are giving it. What is the problem?
No, I'm not saying that. I am saying that today 148 is naturally above after 148A.
Yes.
But 151 sanction
Is
cannot
given after 148A but before 148.
That's right. 148A is on 7th of April.
All right.
And the sanction is prior to 148A.
Sanction is for 148, not for 148A. That is what I am telling. You are not being able to understand. Sanction is required for issuing notice under 148.
That's right. I agree with you. I
if
bow
you
down.
agree with me, then 148 notice is issued on what date?
148 notice, my lord, is at page 36. 148 notice is given on 7th of April.
The sanction is of the same. Is prior to that. What is wrong in that?
But only one thing.
After issuance of 148, there cannot be sanction. Sanction is prior to 148.
Prior to
148.
But sanction, my lord, the 151 sanction has to be passed by the authority which is mentioned under 151 on the basis of some facts that come before the authority. Now there are judgments galore, my lord. Your lordship has even dealt with it. My lord, those judgments say that 151, the authority cannot pass a cyclostyled order. He has to give a finding that he has reached that reasoning. Now that has to be on the basis of a 148 order.
No.
No, this is a jurisdiction. I understand there's been a delay. There has been latches, but there's still a judicial
explanation for delay and latches.
I'll address that, my lord. May I just take one more minute for my satisfaction and the court satisfaction? Only on the 151 and 158A point, my lord. I am saying that 148 will come after 151. I am not joining issues on that. But 148A has to precede 151. Without the order under 148A, no sanction can be granted.
148AD and 148 can be issued together. They have been issued together. What is the problem?
Post the 151. 148 can be issued post 151. But I'm saying 148.
148A also can be issued post 151. See 151.
That.
Let us read 151.
Lord, may I just read for my Lord convenience once, my Lord? Specify that authority for the purpose of, this is sanction for issue of notice. Specified authority for the purpose of section 148 and 148A shall be the additional commissioner or the
So
additional.
this is the name of the authority.
Yes.
Sanction is to be given prior to the issuance of notice.
Under 148.
Yes.
Yes.
And 148A both. See the letter. See the opening sentence of 151.
Specified authority.
148 and 148A. Who is the specified authority? Now for 148A, 148A notice is issued on 7th of April 2024.
Yes, which is fine. I'm
Right?
not disputing the
sanction
148.
sanction is on 6th of April 2024.
148 is absolutely fine.
Similarly, 148 notice issued on the same date. Sanction is of 6th of April. Where is the
Well, so the 151 notice would be with the sanction is being.
151 no notice is issued.
I'm sorry, the 151 sanction is
Yes.
being granted, well, without arriving at a finding. It's
151 sanction is not required to sanctioning authority is not required to arrive at any finding. Sanctioning authority has
No,
to
my
be the authority.
But
that
I'm
has
not,
to
my lord,
satisfy.
I'm not in that case. My lord will allow me to come back. I am carrying one judgment where, my lord, I'll demonstrate that under the
That
150,
sanctioning
the
authority,
sanctioning authority cannot pass a cyclostyle order. It has to be on the basis of some finding. My lord,
Yes,
there's
this is enough.
the judgments of the
This
Delhi
is
High Court
enough.
now.
Page 22. Reasons are to be recorded. Finding is not recorded. Reason is recorded, and reason is based upon the facts and circumstances of the case and the proposed draft order. I am satisfied that this is a fit case for this. This satisfaction is to be recorded. That has been recorded.
But without there being a proceeding which is
No
concluded under
judgment is required
148.
to be passed, sir. They are not required to pass a judgment.
No, I'm not saying like a
Because that's it,
quasi-judicial
this is
body. I'm
sufficient.
not saying like a
Because
quasi.
at sanction, if you want to hold a mini trial at the stage of 148 AD, another mini trial.
No, I'm
issuance
not.
Of 148, another
no.
mini trial. That's
No,
not
I'm
the-
not saying there's a trial.
Then the cycle will never be completed. This is good enough.
But
This
then
is
the
good enough.
148.
You show me the judgment you want to show, I'll give my judgment because this is good enough.
But then would it be your lordship's pleasure to allow me to come back tomorrow itself? I'll
Why?
come. No, I'm not carrying that, my lord. But I had gone
You
through
should
it.
have,
Well, I'm
because
not.
that was your main point.
Well, because I did not, my lord, only for a very specific reason. Is today, if I read the 151 does not require 148A to precede it, then 148A becomes infructuous. Because
Why
then there is no without a hearing, there cannot be a sanction.
No, for purpose of sanction, there has to be a hearing.
And
This
there
is
has to
news
be
me.
a finding.
This is a news to me. For the purpose of sanctioning, no hearing. It's an internal thing, sir. The authority concerned is to be satisfied that yes, this case needs reopening. There is no intervention of the SSE at that stage at all. Not at all. The SSE is required to be heard only by the assessing officer, not by the sanctioning authority. Sanctioning authority is an authority superior to the assessing officer who only sees as to whether sanction is to be granted for reopening or not.
By way
at
of
that stage,
by-
assessee is not required to be heard.
No, not heard, but at least to look at the
He
148A
has done
order.
that. He has done
148A
that.
order. He is not.
No, not the order, draft order. Sanction is to precede it.
Well, then
So
I'll
if
bow
he
down.
reads at the order, then
No,
how
if,
will it precede?
if my lord is of the opinion, then I'll bow down to that, my lord.
No
151.
opinion, that is the statement.
That if that is, I understand, my lord, I'll not. Well, then may I go to the first limb? My lord? Otherwise, if I'm unable to satisfy, I would ideally come back. Or there's another argument that I was placing that 50 lakh threshold for crossing the limitation period, my lord. They have, my lord,
You take it before the assessing officer. The assessing assessment proceedings have not yet been completed. You have come after 1 year. Assessment proceedings have gone on. 142 notices have been issued.
Yes.
So if you have participated thus far, you participate. You say to the assessing officer that you don't have jurisdiction. You already have that point. And why did you not take all these points in 148 AD?
148 I did because I had asked for an extension. They did not give me 148 notice. Order was passed. I asked for time till 10th of April, 7th of April. They passed the order under
the judgment you want to show. I'm giving you one more day.
Well, may I just take instruction on that one? My lord, my instruction is, my lord, we'll go back. Only one thing, my lord. I'll go back. I'll take the same point because now 148A chapter has been closed completely. There is an order which is staring me at the face. So I'll need liberty of the court, my lord, to take the jurisdictional point because now
that is always there.
No,
You
my
take
lord.
all points before the assessing officer.
My lord, this is faceless, my lord. This is
so what? Faceless, you'll be granted a hearing. You will be entitled to file your reply. Everything.
There's a representation that I'll be entitled, but Lordship specifies that I can take the point of jurisdiction also regarding
You
that
take the
this
point of
that
jurisdiction. Why
limitation under 149. Lordship kindly records that, at least as my submission, Lordship records it. I'll go back.
you- as may be admitted by interest has become applicable after this 2020 amendment. Before that, interest was not the part of the pre-deposit. Only tax in dispute.
My lord, subject to correction, my lord.
In respect of 129 only. Yes. Penalty, 25% of the penalty in respect of 129. Yes, from 1st of October, penalty also 10% of penalty on season. When the goods are in movement. No. Section 107 has been amended. 108 has been amended. There are 3 criteria now. There were 2 earlier. 3 have been in. But tomorrow will be. But in any case, yours is prior to October 2025, isn't 2024?
My lord, prior to that.
2025. The amendment is very recent.
My lord, it is from October 2025.
Yes, 1st October.
My lord, kindly takes page 49 of my application, my lord, the adjudication order.
Mr. Banerjee, if he has put in the pre-deposit, then what is the problem? 3 days delay. Three days delay. No. Yes, show me the pre-deposit part. Delay we shall condone. 3 days delay, condonable period.
My lord, kindly takes page 108 of my application.
108.
My lord.
Yes.
My lord, in paragraph 5, if I may please. My lord, he says that I find that the instant appeal has been filed of the disputed amount of tax amounting to 21,53,505. This is the amount which I disputed while filing the appeal. Out of the total confirmed amount of 26,31,154. So, my lord, the difference I've already admitted and paid by DRC 03 against order so and so dated so and so, which was passed by the Assistant Commissioner Central Tax, Kharagpur Division. I also find in APL 01 that the appellant admitted demand amount of 434,732.
The balance of 4 lakh and odd, which you have not disputed,
my lord,
that tax you have paid.
That tax I have paid.
Then show me where is that.
My lord, it is not adduced in the application, but my lord,
No, but that needs to be put.
My lord, I have a copy of the DRC 03.
Then Mr. Banerjee, I am doing this. I am remanding it to him. He will consider this afresh. Yes, provided that you satisfy, he'll consider this afresh.
My lord, may I pray for this? My lord, condones the delay on the issue of pre-deposit. My lord, the
Yes,
appellate
I'll condone the delay and the petitioner assails an order dated
next bill of entry, my lord, page number 27, my lord. Page number 27, my lord. This is the bill of entry, my lord, in respect of 24, my lord. And the payment date is 7/7/17, my lord. Next page, 28, my lord. But that means I have satisfied the criteria as laid down in the under section 40, subsection 5, my lord, within the period of 1 month. And the now, my lord, now to carry it forward, my lord, as per the section, the provision of the law, my lord, 145, my lord, a trans 1, my lord. Trans 1 is the form whereof I declared that this amount is to be carried forward, my lord. My lord, I filled up the trans 1 form, my lord, in page number, my lord, 29, my lord. 29, my lord, and which was acknowledged, my lord, in page number 32, my lord. My lord. That input duties of 34, 86, 488. Well, in fact, 31, my lord, lordship comes, my lord. Yes. But 31 from the top, my lord, goods and service tax, thereafter dashboard return, trans 1, my lord. My lord. And the amount is 33, 84, 7279. My lord. Herein after, my lord, I made a mistake, my lord. I made a mistake, my lord. As per the provision of the transfer form, my lord, it ought to have been declared under serial number 7B, my lord. But by mistake, I declared in under serial number 7A. Now, my lord, as soon as I add this, I noticed this, my lord. My lord, I in page number 34, my lord, there is a help desk under the government of India. Well, I write to the help desk, page number 34. We are trying to revise the GST form transfer, but we are unable to do so. We have to file. We have to fill up the data in 7B instead of 7A. That's what we got, my lord. My lord. Earlier we have submitted the data in 7A, my lord. The next page, my lord. The reply from the help desk, my lord. This is the help desk automated response confirming the receipt of your request. The request this has been registered with us, and the request status is open, my lord. Page number 36, my lord. Now the reply. Reply, my lord, dear taxpayer, our record indicates that you have submitted transfer resulting in posting of the credit in your electronic credit ledger. However, it was
electronic digital signature was not there.
Not there. My lord, digital signature was not there. Electronic. However, if you have received a email confirming filing of transfer with the ARN, you are requested to respond the email to this. My lord, I had received the acknowledgement was with me, my lord, as per page number 33. So digital signature goes off, my lord. Only as regards to that, I'll have to make another application to the concerned authority, my lord, as mentioned there below, my lord. Page number 37, my lord. To that authority, I make a request. We are in receipt of your email. This for non-submission, non-submission transfer DSC. In this connection, we would inform you that we have filed transfer with DSP by this. Further, we would like to inform you that we have to post the data due to amount wrongly taken in point number 7A instead of 7B, my lord. This was bought. Next page, my lord, 38, my lord. Yes. Now, what I do, my lord, as because it was not progressing, my lord, I intimate to my authorities, my lord, local authorities, my lord. 38, my lord, to the superintendent, central excise, and the receipt of the superintendent is below, my lord. My lord, after I intimate them, my lord, now they proceed with giving me a notice, my lord, after scrutiny of the returns, my lord. My lord, 39, my lord, in 1.1 introduction, my lord. Also, you found, my lord? Yes. My lord, 1.1 last two lines, my lord. Return under entry 7A of table 7A
under the relevant provision of subsection 140 of the CGST Act, my lord. This was the issue. My lord, hereinafter, my lord, I gave a reply as per in page number 42. My lord, it is the receipt is in page number 42. The reply is in page number 43 onwards, my lord, whereof 2.2, my lord, page number 44. I bring this to the notice of the concerned authorities, my lord. 2.2, the taxpayer requests to see the above paragraph that the department has understood the mistake in filing transfer, but nothing has been communicated to the taxpayer. The GST law being new and in
So if
implementing
you had filed it in table 7A instead of B, then in that case it would have been correct.
Correct.
But you wrongly filed it in 7B.
7A.
You,
My lord, my lord.
You
If
filed
lordship,
wrongly in 7B.
I filed it wrongly in 7A.
You filed wrongly in 7A.
7A,
If you had
my lord.
filed in 7B, it would have been correct. You
My lord,
wanted
if your lordship takes this trans 1, my lord.
So if the correction had been allowed, then in that case, this notice would not have come to you.
Well, this is a trans 1, my lord, form. At the top, my lord, trans 1 is mentioned over there. My lord, thereafter, lordship, it comes down to 7, my lord. 7 small b, my lord. My lord, 7 small b, amount of eligible duties and taxes, VAT oblique ET, in respect of input or input services under
It should have been filed here in 7B. And you mistakenly put
in
it
the
7A.
upper column, my lord, 7A.
And this you wanted to correct, which has not been correct.
No, no. Thereafter, my lord, the order was confirmed, my lord, as per page number 62 DRC 7, my lord. I went to an appeal. Appeal order was also confirmed. Now, my lord, I'll place before your lordship, my lord. My lord, need I show this, my lord, appeal order and the DRC 7, my lord?
Only on this point.
Only on this point, my lord.
Yes.
Now, my lord, I place before your lordship, my lord, judgment of our High Court, my lord. My lord, paragraph 4 onwards, my lord. While filing the return in trans 1, it appeared that the applicant entered the amount in a wrong table due to technical understanding. As a result of which of this was credited to the CGST account. The applicant has realized the mistake, submitted and representation to the authorities on this, requesting to provide them the facility of filing trans 1 and 2, which was available on the GST portal till this, and accordingly submitted the same. The prayer was also made to defer the proceeding under section 73(5) of the Act. The 7, my lord, the applicant once again made a representation, my lord. This is the same representation, my lord. Thereafter, 8, my lord. The consistent case of the applicant, paragraph number 8, my lord. The consistent case of the applicant is that they would fall under 7B, and inadvertently the transfer was filed under entry 7A, and the applicant explained that since they are not registered under the Central Excise Law, they are required to file transfer under 7B. The adjudicating authority, while passing the impugned order in the writ petition dated this, candidly accepted the same, that the mistake has occurred, my lord. Thereafter, my lord, the order, my lord, paragraph number 11, my lord. Paragraph number, my lord, I read out. Thus, taking note of the law and the subject as well as the fact of the case, it is a fit case where the direction should be issued to the authorities to enable the applicant to rectify the mistake and submit the GST trans 1 under heading 7B of table 7A of GST trans 1, and the applicant are directed to comply with the same within 3 weeks from the date of receipt of the server copy of this order, after which the adjudicating authority is directed to verify the same, and if admissible, extend the transitional credit to the applicant. It is pointed out that the learned senior standing counsel for the department that appropriate direction may also be issued to the nodal.
In this case, the adjudicating authority had admitted that there is a mistake.
Yes. Yes.
In the case,
yes.
In your case?
Yes, my lord. No, not 40. 105.
8.7 page.
The appellate order. Again. The applicant submits that, my lord, the personal hearing, my lord.
What did the Honorable Supreme Court say in this judgment of Philco trade?
My lord, it was, my lord, many of the dealer, my lord, could not avail that filing of the transfer, my lord. It was extended, my lord, by Philco.
And this circular was issued based on the Supreme Court judgment. So if somebody missed the time, what will happen to that? If somebody has missed the time, then what will happen to that?
No, my lord. My lord, there are certain judgments.
Clearly saying that already an option has been given, further option. Maybe there has been some technical issues that something, but in terms of the general direction, the window was open. So at that point of time, why did you not avail of the opportunity when the Supreme Court has clearly mandated the same?
But should they be penalized for that when it is apparent that it is a mistake and the portal indeed did not?
And non-verification of the
But his mistake and his attempt to correct the mistake at the inceptive stage, at the initial stage, and your portal not allowing him to do so because of glitches. So it cannot be solely attributable to him. You have the copy of the circular.
My lord,
I see the language.
well, there will be certain difference, my lord. Lord, what is submitted, my lord? My lord, I say there is a Delhi High Court judgment which is supporting me, my lord. I say, Philco was the petitioner who had not filed, my lord. They were extended. The window was extended, my lord. In my case, my lord, I had filed it. But the correction was not. I was not able to do the correction, my lord. And neither as because I have already filed once, my lord, I cannot file twice, my lord.
And what is this circular? You have a copy of this circular?
No, my lord. That circular
because
I do not
this
have.
Circular they have relied on.
My lord.
You need to see the circular.
But it was based upon Philco, my lord, whereof the Supreme Court said that the window
if
is.
I can see the language, I'll be able to distinguish that.
My lord.
Nobody has.
My lord, sometime, my lord. But in fact,
heard learned advocates appearing for the respective parties.
But in fact, my lord, here the Delhi High Court judgment
14, my lord, I am appearing for the petition. My lord, the 14 onwards, a group of cases are, my lord, that is similar in nature, my lord.
What is this application for?
My lord, this is an application, my lord, where I have filed a refund application, my lord, which till the time of I filed this writ petition, not granted, my lord. My lord, the petitioner is a manufacturer of agarbatti, my lord. So that is why he is entitled to claim a refund of excess input tax credit available in his electronic credit
So
ledger.
this application is based on
Oh,
subsequent.
my lord, this is, yes, my lord. During pendency of this application, my lord, my lord, may I? My lord, this is during pendency, I filed this application considering that there was no action on the part of the proper officer in disposing of my application, despite issuing the acknowledgement. My lord, thereafter, during the time, all of a sudden in September, they initiated the show cause notice based on the subsequent developed facts, and thereafter they have passed the orders, my lord. That is why I filed this, to bringing all these cases, all these
What is
subsequent
the
facts.
subject matter of challenge in this
My lord,
application?
subject matter, my lord, my lord, I am already covered by this Honorable High Court's division bench, my lord, order, my lord. But despite
Refund
that,
application you
yes,
wanted to be processed, and what was done thereafter?
my lord, thereafter they have not done anything till the time I have filed the writ application, my lord.
No, but how are you challenging the show cause notice by way of an application?
No, my lord, that is a subsequent fact, my lord. My lord, that I am not
Is it
pressing the
relatable
can
to the
application
refund?
right.
Is
Yes,
it
my lord.
relatable to the refund?
Yes, my lord.
How?
My lord, they have issued the show cause notice in respect of the refund application after filing this writ petitions, my lord.
In respect of refund application, why show cause has been issued?
My lord, that is the procedure, my lord. There is a provision, my lord, but that has to be done within a specific
As
time.
to why refund will not be granted?
Not be rejected, my lord, and my lord, that was supposed to be done in a specific time manner, my lord. My lord, my case is particularly my case is that they have failed.
But now, since they have passed an order, is this order not appealable?
It is an order, my lord. But my lord, I have already covered, my lord. That is why, my lord, at the first instance, my lord, I was.
Why?
My lord,
What
I
will
am
the
covered.
appellate authority do? He is already dismissing it on ground of
No,
limitation.
my lord.
He has a lot of time.
No, my lord.
And writ courts are flat.
My lord, kindly consider, my lord. Now this order, even the show cause notice, these are already all are in nullity, my lord. Because my lord, honorable my lord, may I first refer the judgment of our Honorable.
Kind of incorporation of legal on where is allowed.
No, it
I am-
can be
I'm not-
allowed, but in this case, I don't think it's right. Because the prayer was for early disposal. That has been done. Now you are challenging the order. No. Ms. Mukherjee.
Yes, my lord.
No. Because your prayer was for early disposal.
My lord.
They have disposed it off. Now you are aggrieved with the order. You
My
apply
lord.
it up in appeal.
My lord, may I, my lord? My lord, I am requesting your lordship, my lord, only to go through this judgment, my lord. This is a division bench judgment of our jurisdiction, my lord. My lord. Time is, you are aware, my lord. Suraj Mangar, my lord. My lord, this issue has already been, my lord, had my case had been heard immediate after filing the writ petition, my lord, within the date I have given as to be returnable under the vessel.
This challenge was to the appellate authorities.
My lord, but in my case, my lord, in my case, my lord,
No,
kindly
Mr.
consider, my
Here, the conscience doesn't permit. You had approached this court seeking early disposal. They have disposed of. Now you are
No, my
aggrieved by
lord.
the order.
My
The
lord.
order, if you are aggrieved by the order, there is an avenue to
My lord,
appeal, never appeal.
I have not filed the writ petition only for the early disposal, my lord.
You
My lord,
wanted refund.
yes, my lord.
That will be by way of an
My lord,
adjudication. That has been done.
my lord,
If you wanted, writ court also would not have granted you refund. All that you could have got by the writ
Yes,
court
my
was
lord.
that the appeal should be heard.
Appeal should be heard or the refund application should have been.
Sorry,
But
the application should be disposed of. That has been done.
my lord, no, my lord, kindly consider, my lord, may I request your lordship to only to go through the judgment, paragraph number 54, my lord. What has been decided by this judgment, my lord? Paragraph 54, my lord, internal page 16 of the judgment, my lord. My lord, that is what I am. My lord, it has to be now it has to be considered, my lord. My refund has already been sanctioned if they have not followed the timeline, my lord. That is what I have, my lord. After expiry of
And
that
if
time,
you wanted to challenge it, there is no jurisdictional error. I don't find
my
any
lord, I am not
jurisdictional error.
jurisdiction. I am not on the jurisdiction, my lord.
If you are not on the jurisdiction, you approach
My
the
lord,
this judgment won't apply.
my lord, this
See, if
judgment
you
is
had approached this court earlier on the ground of any jurisdictional error, I would have understood. There is no jurisdictional
lord,
error.
may I
Writ court cannot be writ court's jurisdiction cannot be invoked like this.
my lord, may I, my lord, kindly consider one thing, my lord. They have
Both these is also there. Again, a new cause of action.
yes, my lord.
This has to be submitted to your lordship because upon supplementary, because there is a high court judgment.
My lord, I am not denying, my lord. My lord, then your lordship, I may pray for a liberty, my lord. I will file afresh, my lord, because
That liberty I will not give because I am satisfied that this should be appealed against.
my lord,
Prefer an appeal. Why should I grant you liberty?
my lord, because the order they have subsequent show cause notice and the order itself, it's a nullity, my lord. It's without jurisdiction, my lord, because they have failed to complete it within the time limit which has been prescribed
Where
under the
said
statute.
that if they fail to do it, it is a nullity. Where is that observation in the judgment that you are relying on?
My lord, that is from the page 54 onwards, my lord.
Page 54, it doesn't say that it will become a nullity. Those are irregularities.
My lord, thereby the admitting the application was in. My lord, they have admitted my application within the time limit, my lord. I have filed the application on 16th January 2025. They had admitted my application by issuing RFD 02.
This observation is on absolutely different count. Please see paragraph 56.
My lord.
Text has to be read in the context. Respondent authorities sought to take advantage of their own wrong in exceeding the time set.
No, my lord, thereafter, my lord.
This was an error within jurisdiction which has been corrected upon an appeal being preferred and an appellate order confirming the wrong done. Here in this case, you have not.
My lord, finally, my lord, finally, honorable division bench, what has done, my lord, they have granted, they have directed the.
Will not be able to take stock of all this.
No, my lord, they will definitely, but my lord, the show cause notice, my lord, the show cause notice.
Turn this court into the appellate authority under section.
No, my lord, I am not, my lord. They have done, my lord, because
they have your writ petition was
yes,
prayer made in the writ petition. Please.
My lord, initially, my lord, it was my prayer. It was my prayer.
That has been done. Now
it was my lord. It has been accepted, my
lord. Not right, madam. Not right.
My lord, may I only pray, my lord, the appeal should be within a very
that
specific.
16 16 এ প্রোকজ নোটিসের ডেট আপনার হচ্ছে
9 September.
9 সেপ্টেম্বর আর রিপ্লাই এর 16 সেপ্টেম্বর অর্ডার ইজ সেম 31st অর্ডার ইজ সেম আর এই প্রেয়ারটা কপি করবেন হ্যাঁ ঠিক আছে
इसका क्या था?
আচ্ছা এক জায়গায় এখানে আরো একটু লিখে দিন ওই সবকটাতে এটা ঢুকবে অলদো
Oh, Jalpai, but you cannot say that. You cannot say that judge has had. You might say that you were not defended properly.
চিঠি দিয়ে জানানো হলো, এবার থানাতে জানাতে হবে। কিন্তু থানাতে জানাতে হবে আপনার ব্যাংক দিয়ে
আমায় ঢুকতে দিচ্ছে না। My lord, today I am praying for adjournment because my learned counsel is in another court. It would be better if the matter will be fixed on 25th November.
An adjournment is prayed for on behalf of the petitioner. Full stop. List this matter on November 27, 2025.
I'm grateful, my lord.
This is, my lord, another period of, for the period May 2025, my lord. But this is a different case, my lord. There they have already sanctioned the refund, granted, and my lord. That is why, my lord, I said, my lord, this is,
Here they have
my lord,
granted
the self reason, my lord. Show cause notice was issued, but finally it was granted, my lord.
So what do you want now?
My lord, I am now, my lord, I am automatically entitled to interest, my lord.
You
So,
make application before them.
my lord, I need not to move any petition, my lord. They are, it is an automatic, my lord. It
So
can
they
be.
will grant. If they
Yes.
don't grant, then you come because
As on date, there is no further action.
yes.
Only, my lord, it has to be
Yes.
taken into the court. My lord, only my humble request, my lord, your lordship kindly make an observation that the refund has been sanctioned without any interest, my lord.
Yes, that I will definitely. Learned advocate.
facts. My lord, if he
Very
would
well
have
put that.
yes, my lord, if he would have disposed of the cases within
Because
the
this-
timeline, my lord,
The division bench decided on the basis of several
My lord,
facts which were there.
factual.
The appellate
My lord, these
authority's
facts
order
are
was
not
also there.
Yes, my lord, these facts are not before your lordship. Gratefully, lord.
Off-court audits. When I would see in audits also, after the order was passed, appellate
Yes.
audits also, it was a case was implicit not the show cause.
Show cause where? Only when there is absolute lack of jurisdiction or there is predetermined. Yes, that is always there because you have taken a decision, because language used in the show cause notice, those things are there.
Gratefully.
Thank you. 21.
Well, I'm appearing for the petition. It's an appeal, belated filing appeal. The appeal was filed admittedly after 171 days of the.
What is the reason for delay?
My lord, it is a company. It is a proprietorship concern under a group named Orun Sai. This group is a century-old group, and under this group there are several companies. This proprietor of this particular farm, Tapan Kumar Bishwas, he was carrying the ancestral business, and thereafter his elder son joined the business. He and his elder son continuing the business for 22 years, more or less 25 years. Thereafter, there is a rift between the elder son and this father, and the entire situation and rift came in 2022, and 2020-24. This entire group business has been a totally mess because of this rift. Ultimately, in 23, that elder son has left the business. Elder son's friend was looking after the taxation. Therefore, he has not taken proactive action, and all these reasons were recorded here. All these
Where is the application for condemnation?
My lord, in page 85, my lord. This is the application.
Who is Ashif Kumar Bishwas?
He's a elder son of Tapan Kumar Bishwas.
How has the appellate authority dealt with this?
My lord, that's the peculiar matter, my lord. Kindly come to page 94. My lord, this matter has a change brief to me. I have gone for another matter before this appellate authority. I found this matter on the first day because all communications are going to the erstwhile chartered accountant. It has been written in the page 94, my lord. In the bottom second paragraph, hirogdpal@gmail.com. Notice was sent. This notice has been sent to that person. I have gone there. I told about this fact before this officer. Officer said one matter is today is the date. So I appeared and take a date. On the next day, I was before the next day I was ill. Over phone I have informed the officer. That has not been mentioned. My lord, in page 92, my prescription is there. In page 90.
These documents you did not produce before the appellate authority.
All documents has been produced. Well, all documents, the appeal has been produced because he has written, my lord. Kindly come to my lord, page 95.
Medical documents you have not produced.
Medical document produced on Xerox copy. Well, original medical document is not with anybody's because today everybody is covered by the Mediclaim. So original document has been gone to Mediclaim.
So I cannot produce original
That is
document.
right. Mediclaim original documents you can't.
Original document I can't produce.
They will take everything.
They take
Except X-ray
everything.
plates or something.
So that's
X-ray plates also you don't get.
the only reason for the is that original medical document has not been produced. That's the only reason has been given. Second page. Only reason has been given. Medical document has not been.
150 days.
171 days.
Family feud, sick.
Well,
grounds are there.
same order. Same order.
One of the good cases where delay should be conducted.
Same.
Happily drafted. This writ petition lays challenge
pray for an adjournment for 2 weeks.
2 weeks.
Because one of the respondent is at Vizag. We have not yet received the receipt of confirmation of receipt of petition. So I have to send.
Service is not complete.
Not complete because I have to send one
Liken it.
person to Vizag
It is
personally.
submitted by the petitioner. December 20. Yes. For a week.
They must have served the copy, but they have served it to the department, not to the copy.
Serve a copy on Mr. Chakraborty. Learned advocate appearing for the petitioner. You are the advocate on record.
Madam, for the petition. Well, this is a case of assessment. Well, your lordship will kindly come to page. Well, this is a case of assessment here 2007-8.
Case of
2007-8, my lord. Case of
7-8.
Yes. Well, case
Assessment year 2007.
2007-8. Well, kindly come to page 24 once. Well, it starts from 24. What has happened? I am telling your lordship in my lord.
24.
Yes, my lord.
Yes.
This is the assessment order, and my lord, your lordship will kindly come to page 26 once. The total tax demand is 9,08,029. Lordship got that, my lord?
Page 925.
26, my lord.
Yes, total
Yes.
tax demand.
Total tax demand. My lord, against that assessment order, I filed an appeal. Now, my lord, appellate order allowed my entire, my lord, allows, my lord, the appellate order allowed my entire expenditure, which was added to my income. And my lord, only, my lord, your lordship will kindly come to page 33 once.
33.
3, appellate order 33. My lord, only in the middle portion, my lord, interest bank charges, your lordship got that, my lord? My lord, only this fourth expenditure was disallowed. My lord, only this expenditure remains there. And my lord, almost all my claim was allowed. Against that, my lord, the department. Well, against that, the department went before the tribunal. Well, the tribunal dismissed their appeal at page 37. Your lordship kindly come to page 37 once.
Yes.
Department went before the tribunal. The tribunal dismissed that. My lord, thereafter, my lord, kindly see page 38 once. Suddenly, my lord, this notice came to me. My lord, assessment year 2007-8, dated 21 November 2023. And my lord, request for payment of outstanding demand. Assessment year 2007-8 under section 143.3, 6,30,000. My lord, I don't know. My lord, therefore, thereafter, my lord, I am noticing, my lord, I have given a reply at page 40.
Yes.
They sought for a clarification that why you have not paid, my lord. I have given a reply, and I have found, my lord, ultimately when I was checking my report, I found that from 2019 they are giving an adjustment of making for the assessment year 2019 they have adjusted 14,000. For 15-16 they have adjusted 26,000, and
Where are you getting?
my lord, at page 40 I have given a reply.
This is in respect of this
This
2007-8.
exactly.
And in respect of 2007-8, nothing is due.
Nothing is due according to my lord. Only 50,000 was there. My lord, my instruction is that has already been paid. Well, from each year, my lord, they are deducting my from refund for this 2007-8, which is not at all payable by me. But at page 41, kindly come to page 41 once, my lord. My lord, this is from the.
Just
Yes, ma'am. Sorry, ma'am.
So in your appeal,
My
ground number 5
yes
was ground number 5 was allowed.
No, everything was allowed.
Only 6.
Only
was
6
partly allowed.
Yes. Every.
Only in respect of 6 something was.
No, my lord. Only say that was also allowed, my lord.
No. 6 was partly allowed. See
Partly.
page 33.
Yes.
During appellate proceeding, AR file details, interest on bank loan 2,52,000 and bank charges such and such are
Yes,
related to
that
his
my lord, ground number
AR
8,
court
my
note
lord.
file.
That is 8, my lord.
Yes, paragraph 8.
8 paragraph.
Paragraph 8, 6 is partly allowed.
Partly allowed. These 4 items were added.
allowed.
Oh, these are allowed.
No, 5 is dismissed.
Yes.
5 is addition of rupees 1.10 lakh.
Yes.
That has been dismissed at paragraph 7.
Yes.
So 5 is not allowed and 6 is partly allowed. So in respect of 5, 1.10 lakh is there. See page 33.
33, my lord. Yes.
Page 33, paragraph 7.
Yes.
Appeal on the ground number 5 against addition of 1.10 lakh. This has been dismissed. A CC's appeal on this ground is dismissed. Same paragraph. Paragraph 7, last line.
Yes.
So ground number 5 is disallowed. 6 is partly allowed. So they have a claim of 1 lakh here.
Something.
1 lakh something.
Not claim, my lord. These are.
And 2,52,000 and odd plus
Yes.
14,000 and odd. So 2,60,000 and odd.
50,000 was demanded against that demand, my lord.
But this shows 3 lakh.
No, but
Addition
well,
of
3
3
lakh is expenditure addition. The 3,50,000 is demanded. That has been paid. That has already been paid.
Very well. Yes. But what are your instructions? Why are you demanding? I need something from the department also, because on the basis of this, there should be some basis to this demand. Please come up with some instructions, because I am passing an order so that you can get instructions. হ্যাঁ ঠিক আছে আসুন আস্তে আস্তে The petitioner is aggrieved
25, my lord, I am for the petition. This is my affidavit of faith. Very short here, my lord. I'll come directly to the point, my lord, and without, my lord, getting into the merits. My lord, my only contention, if your lordship finds, my lord, kindly takes up the impugned order that starts at page 62. And my lord, the issue, my lord, which I want to canvass is at page 69. It kindly comes to
This is not against state. So who is appearing for the union? You are against the adjudicate, I mean, order in origin.
Well, I am only seeking for remand, my lord, on the grounds. My lord, kindly have a look at page 69, para 5, my lord, where it has been stated to provide natural justice. 3 dates of personal hearing were given to the party, and no one on behalf of the noticee had appeared on any of the personal hearing. My lord, this I say is absolutely incorrect. My lord, no notice, no email, not even in the portal. My specific instructions are no notices, because lordship will find not a single date of hearing is mentioned, not a single date of the notices are mentioned. A generic statement that it was given, I was absolutely unaware, and my lord, this order was passed. So my lord, I am seeking, my lord, for remand, my lord, where I can make out my case.
I'll have to hear them whether.
Lord, may I just, my lord, indicate one thing? Lord, I am making an allegation, Lord, he must meet my allegation. Lord, they let them file an affidavit, my lord, to the extent.
Affidavits not required.
Lord,
Let them say what they have to say first, then affidavits will be considered. Tomorrow may be difficult. Ask him to come with instructions. I am passing an order. The writ petitioner
I bow down, but my lord, if I have, I will lose a forum.
not necessarily.
I'll lose a forum.
Can also decide.
I'll lose
Very
a
well,
forum,
let
as well as, my lord, I will have to pay the pre-deposit of 10%.
Let them come first. Let them.
Great.
Lord, this is my application for condonation of delay, my lord. The delay is 172 days. My lord, I had not formally filed a condonation of delay application, but my lord, at the stage of appeal, a show cause was issued upon me to explain the delay. My lord, therein I had explained that, my lord, this is 2023. My lord, the portal was redesigned after that. My lord, in 2023, the additional notices and orders portal and the notices and orders portal were not kept side by side. And therefore, my lord, I had missed the notices and orders. I came to know only later, and thereafter I had preferred an appeal. My lord, additionally, I also have a natural justice point, my lord, in the sense that no personal hearing was afforded at the time of adjudication. My lord, at this stage, my lord, the only prayer is that matter may be remanded to the appellate authority for a decision, my lord, on merits.
Where is your application for condonation of?
My lord, I had not filed a formal application for condonation
No,
delay,
but
but
something must be there on record.
my lord, kindly comes to page 84 of my application.
Page 84.
My lord, the second paragraph. My lord, if I may please, my lord. The delay report. My lord, that apart, if my lord comes to page 29, my lord, once. My lord, as per subsection 4 of section 75, he has to mandatorily afford me an opportunity of hearing. But my lord, if
That's
this
right, but that is after you cross the hurdle of delay.
but my lord, this is statutory violation, my lords.
Then also you have to be within the statutory period for filing an appeal. This will be a point for annulling the adjudication order, but this point you will be able to urge only if you cross the hurdle of delay. If the appeal is filed beyond the period of limitation, you will have to explain the delay first.
My lord, my only prayer is condonation of delay.
Yes, Mr. Chakravarti. How many days delay is there?
170. My lord, 172.
Pay some costs. 172 is, I have not been allowing without costs.
In fact, my lord, 75 force, 4 Cs, my lord. And hearing has to be.
That is right, but this point you will
matches, my lord, on their part.
this point you
Thereafter,
will
my lord, as your
this point you will be
your lordship.
this point you will be able to urge only if you cross the hurdle of delay, not before that.
No, but
Because that is
giving a point to your lordship.
yes, pay some cost because I have followed a consistent
Yesterday I
way
have
of telling. 10,000. Yes, that is this writ petition has been filed assailing an order
my lord, item number 27, my lord, I'm seeking an adjournment.
My lord, my lord, my lord,
Praying for time.
well, let it be admitted as because I've challenged the virus of 16(2)(c, my lord. Can be, my lord, many matters, my lord, already has been admitted, my lord, for exchange of evidence. No.
No,
My lord, my lord, in
he
any way, my lord,
the notification, you file your affidavit. You don't want it to be admitted also. No, up to your lordship now. You want to contest the admission, you want dismissal at the threshold, or you will file your affidavit, and then because no unnecessary wastage of time will not do. If you want to argue, then we will go full-fledged. No question, you want to argue or you want to get it admitted. That is what he
my lord,
wants.
the interesting part is, although he's arguing, my lord, my purchases are before the cancellation of the registration, my lord. They have not gone through the brief. Yes, I'm agreeing. But
only affidavits. If you want stay, then he will fight.
Well, stay, my lord.
Then so he will fight. Then we'll have to fight.
Well, we have the document. My lord, let it be adjourned, my lord.
On the prayer of the learned advocate appearing for the petitioner,
Lordship, I am for the petitioner. Lordships, in this matter, my appeal was rejected under GST only on the ground that pre-deposit was not made, Lordships. Thereafter, Lordships, what has happened, the department has recovered the entire tax in dispute amount from the electronic credit ledger. Lordship, my only small prayer in this writ petition is that since the entire amount has already been recovered, Lordships may kindly allow the matter to be heard on merits before the appellate authority.
no, without putting in pre-deposit.
Lordships, the entire amount has been recovered already. I have annexed the credit ledger as well, which shows that the
The appellate authority has dismissed it on the ground of pre-deposit.
Yes, Lordships. Non-payment of pre-deposit.
Order.
Your Lordships, the recovery was also in 2023. Your Lordships, I have made a small representation in the writ petition with respect to the delay, but Your Lordships, that is not very substantial. But yes, Your Lordships, that is there. That delay is there, Your Lordships.
Yes.
It is there, Lordships. But Lordships, now the coming matters 30, 32 to 34, Lordships, almost of the same way, Lordships. They have recovered the entire amounts. They have left with no money now. One order in the Lord.
When did you file the appeal?
Lordships, the appeal was filed on the 16th of February 2023.
And when has the writ petition been filed?
Lordships, the writ petition was filed
August 2025.
August 23, Lordship.
How do you get around? Very difficult.
Lordships, may
Because then tomorrow also somebody comes and files a writ petition.
Lordships,
It will be a precedent.
Lordships, what has happened, Lordships, now since
There should be some semblance of explanation. There is nothing.
Lordships, it is there, Lordships. I've made a very small prayer at page number 10, Your Lordships. Page number 10.
I've read.
Yes,
Page
Your
number
Lordship.
10.
That is the only thing, Your Lordships. Your Lordships, in the coming matters as well, Your Lordships, what has happened as of now, in all the financial years, the recovery has been done. He is completely out of money, and Your Lordships, that is why he has come up to revisit his cases, Your Lordship. That is the only thing. Lordships, may kindly consider very
No,
very small.
consideration will be on the basis of pleadings. If your pleadings are not there, how do I do that? 100 days, 150 days, 2
Lordship,
years,
Lordships, what has happened, the
more
Lordships,
than 2 years, almost 3 years.
the appeal was filed in time, Your Lordships, but an application was also made for the stay of the requirement for pre-deposit, Your Lordships. That was also not taken into consideration. That stay application is also there, Your Lordships, in this. But Your Lordship, the only requirement was non-payment of pre-deposit. Now that the entire amount has been recovered, Your Lordships, the only prayer is that the appeal be revived so that the matter can be heard on merits, Your Lordships. That is the only thing.
Very difficult. The deposit was not a very small, was not a very big amount.
Lordships, in the coming years, the next petitions, Lordships will see the pre-deposit amount is exceptionally high. The demands is of 1 crore.
Coming years means?
Item number 30, 32, 33, 34, Lordships. The same person itself, Lordships, the redeposits were pretty high, Lordships.
Past, in the same year?
Not different years, Lordships. Yeah, 2023. And all matters 23.
All matters of 23. Then let me consider them because difficult in this way. Do you have any precedent?
Yeah, Lordship, I have annexed one order at page number 79. Lordships, may kindly. Delay was not there, but on this,
that only.
Your Lordship, on delay aspect, there is nothing as such. But Your Lordships, on that particular point, that since the pre-deposit has already, the entire tax demand has already been recovered, the matter was allowed to be heard on merits by the appellate authority. Lordships, the petitioner has not been heard on merits. That's the only thing. Kindly allow one opportunity so that the merits can be heard, Your Lordship. That is the only prayer which I am making at this point.
Not proper. Come tomorrow.
Lordships, may kindly take this matter on Monday. Tomorrow I am not in town, Lordships. On Monday. Lordships.
Monday. Sommar ko. Aspirate for this. What is the list of?
Item number 1.
Lord, I appear on behalf of the petitioner. My lord had
I'll be
occasion
repeating
to appear in this matter, my lord.
That
For
is
the
why these are all under
lordship,
document.
lordship.
এটা একটা অর্ডার রেকর্ড করে নিন, এটা সেম অর্ডার হবে সবকটাতে, 8খানা আলাদা আলাদা হবে, কারণ সবকটা রিলিজই Item number 3. Same order.
Same order. Same.
Item number 4. Same order.
Same order. Same order.
Released.
Go to Chief Justice.
Item number 5.
I appear for the petition.
Released. Number 3. Released. Item number 7.
I am for the petitioner, my lord. Same order.
Released. Item number 8. Released.
Lordship,
is
I am
to
for
be
the
released.
petitioner. Last occasion.
Acha, it is for what? It's
Sir,
alada.
it is.
You have your letter.
Yes, Lordship. And there is an instruction, Lordship.
Give it. Learned advocate appearing for the petitioner Yes.
They have filed appeal today.
Yes, you have been served with a copy.
They have served me by email just 1 hour ago.
So you take it
1
into
hour.
stock.
Sir, 1 hour.
You take it into stock. You want to come back? I'll.
Yes, my lord.
I'm recording that. You come back.
Well.
Affidavit in opposition. করে রেখে দেবে না হারিয়ে যাবে এক জায়গায় কোনো ফাইল
For the petitioner, Your Lordship. Your Lordship, the petitioner number 1 is a custom broker firm, and the petitioner number 2 is the only active partner of the firm.
একটা কাগজ দিয়ে ইয়ে করা যায় না ভীষণ ঠান্ডা লাগে সব একসঙ্গে চলে আসে কিছুক্ষণের জন্য বন্ধ করে আবার চালু
No, Your Lordship, the petitioners are carrying on the business of custom broker, Your Lordship. Your Lordship, the what is a custom broker is defined under the custom broker regulation, Your Lordship, which is passed under section 146 of the Customs Act. Your Lordship, basically, Your Lordship, the custom broker is the agent when for the importers and exporters on the basis of the documents provided by the importers or exporters, he files the bill of entry or shipping bills, Your Lordship. Your Lordship, he is required to check the KYC, Your Lordship, which is basically, Your Lordship, GST registration, import-export code, license from the Director General of Foreign Trade, and then he has to verify this is the credential of the importer, and with that, he will check the invoice, packing list, and on that basis, he files the bill of entry. So, Your Lordship, here what had happened, the goods were overvalued, Your Lordship. And Your Lordship, the goods were 100% examined and valuation was given by valuer. After that, the appraisement section of the custom further increased the value of the goods. But Your Lordship, the goods were subsequently on examination found to be grossly overvalued. So Your Lordship, they have imposed personal penalty on Your Lordship if the custom broker violates any of the regulation under the custom broker rules. There is a penalty of maximum 50,000 and there is suspension of license, etc., revocation under the custom broker regulation. So, Your Lordship, if they want to proceed against the custom broker under the Customs Act, Your Lordship, they have to specifically show that he is an abettor, Your Lordship. And Your Lordship, to call a person as an abettor, Your Lordship, there has to be knowledge, intention, and connivance, Your Lordship. Unless that can be shown, he cannot be charged as an abettor, and these personal penalties cannot be imposed on him. So, Your Lordship, what had happened, huge penalty in Your Lordship, Your Lordship, amounting to 21 crores in all, has been imposed under 6 petitions, Your Lordship, out of which 5 are in the list. One is yet to be listed. Your Lordship, the date given in the status is 24th. So, Your Lordship, this is the total penalty on him. 5 is in the list. All 6. Your Lordship, my mistake.
Very well, no issues.
Your
So
Lordship,
the order impugned is the order imposing penalty.
one of the orders, first
That
matter,
not an appealable order.
Your Lordship, it was an appealable order. But
Yes,
Your
then
Lordship,
why should we entertain it
Your
as a
Lordship.
writ?
So, Your Lordship, from this paper, Your Lordship, which I have just handed over,
Yes.
Your Lordship would see that the penalty is in all 21 crores, Your Lordship. As per section 128, Your Lordship, of the Customs Act, we could have preferred an appeal. But to prefer an appeal, Your Lordship, there is a mandatory pre-deposit as per 129E of 7.5%, Your Lordship.
But can that only be a ground for entertaining a writ petition?
Your Lordship, I have no financial position to deposit such an amount. And Your Lordship, for the maintainability of the writ, Your Lordship, if I can show that the order is in violation of law, rules, procedure, and natural justice, and therefore perverse, Your Lordship, the writ petition will be
Yes,
maintained.
if you can show that it suffers from any of those
Your
errors, by which if it is inflicted or it can be entertained, then in
Your-
that case, yes, I'll entertain.
Your Lordship, Your Lordship,
Even if the appellate remedy is there.
Your Lordship. So, Your Lordship, I'm not citing the judgment that writ can be made.
No, you show me that the order is erroneous
Your Lordship.
to such
So,
extent.
Your Lordship, there are several points on which I say that the order is perverse. Your Lordship,
Either it should be ultra vires, which is not the point involved, or violation of natural justice,
Your Lordship.
or infringement of fundamental right, or a absolutely against law.
Your Lordship, one more point
Or if it
before I
is
start.
without jurisdiction.
Your Lordship,
Yes.
Your Lordship, also your adjudicating authority, Your Lordship, is bound to consider the judgments or the law laid down by the appellate tribunal or appellate authority or by the courts. So, Your Lordship, even if it is in violation of law, Your Lordship, expressly. So, Your Lordship, the first point which I had also mentioned yesterday is that penalty has been imposed twice over, first on the firm and then on me also. So, Your Lordship, straight away, if Your Lordship takes page 239, volume 2, Your Lordship.
ঠিক আছে, অবশ্যই না, Page 239.
39, Your Lordship. Straight away, I'm coming to paragraph 19.3. This is the part of the order impugned where finding against me is given, Your Lordship.
Yes.
Your Lordship, MS Chatterjee and Company, notice number 5, and Shri.
Yes, yes, please.
Yes, Your Lordship. And Shri Ashok Kumar Chondo, notice number 6. Ashok Kumar Chondo, partner of MS Chatterjee and Company, is a part of well-trenched conspiracy. So, Your Lordship, their allegation is against me first. And now, Your Lordship, straight away, Your Lordship, to page 254, Your Lordship.
$254.
Roman 11.
Yes.
Your Lordship, first the penalty is imposed on Chatterjee and Company. 12 again on Chatterjee Company. 13, Your Lordship, against me, the Ashok Kumar Chondo. 14 against again on Ashok Kumar Chondo. Similarly, Your Lordship, at Roman 23 and 24, which is starts at page 255. Towards the end, Your Lordship, penalty against Chatterjee and Company, and then again on Ashok Kumar Chondo, Your Lordship.
Yes.
Now, Your Lordship, I would rely on a judgment on this point, Your Lordship. 2013 287 ELT, page 54, Punjab and Haryana, Your Lordship. Your Lordship, paragraph 11 of this judgment.
Yes.
Your Lordship, may I place paragraph 11, Your Lordship? Having perused the observation of the learned single judge of the Calcutta High Court in the case of Taraknath Sen, Supra, we find that a firm is a mercantile usage in the mercantile usage is the firm in its own. Strictly in the eye of law, it is not a legal entity like a natural person.
What I said yesterday.
Your Lordship. Therefore, the rights and obligation of the firm are really the rights and obligations.
Yes.
Your Lordship, with this, I would also cite the judgment of Calcutta High Court, which was relied on, Your Lordship. AIR 1975, Calcutta 337, paragraph 16 and 17, Your Lordship.
It is quoted there.
Your Lordship.
It's quoted there.
Your Lordship.
The previous paragraph.
Your Lordship, I need not hand over, Your Lordship.
Not required. You
Your
are
Lordship.
formally citing that also, you give it to me.
Your
Because you need not read it again.
Your Lordship.
Give a copy so that I can record that.
Gratefully. Now, Your Lordship, this was the first point. Secondly, Your Lordship, if Your Lordship again comes back to page 239, Your Lordship, the operative portion. Your Lordship, again, Your Lordship, here, Roman 1, Your Lordship.
Roman 1.
Before your so Your Lordship, I'll just place, Your Lordship, from paragraph 19.3. Your Lordship, they said that I'm a part of the well-entrenched conspiracy in collusion with Saurabh Johri and others in the subject smuggling of inferior quality stones in the guise of import of rough precious stones. And Your Lordship, MS Chatterjee and company under the active control of Sri Ashok Kumar Chondo. So Your Lordship, here also they are admitting that Ashok Kumar Chondo is in active control, has never been in contact with actual importers, never verified the KYC of the actual importer. So Your Lordship, this is the allegation that I did not verify the KYC. Now Your Lordship kindly takes page 87 in volume 1. Your Lordship, this is my reply to the show cause. Here I have specifically referred that I received all the KYC, Your Lordship.
Page 87.
Yes, Your Lordship. Paragraph 2.
Paragraph 2.
Your Lordship, I have received and checked all the KYC. I have also annexed the KYC. Now, Your Lordship, if Your Lordship takes page 91, Your Lordship, this is the import-export IEC license of the importer.
Yes.
Now, Your Lordship, at page 92 is the bank certification of the importer. Page 93 is the GST register.
Hardly readable.
Yes, Your Lordship.
Absolutely.
Your Lordship, they are required to a bank signature verification.
What is the purpose of this page 92?
Your Lordship, these are the KYC documents which a custom broker needs
This is
to
in
check.
support of KYC.
Because Your Lordship, it is not physical. There's a judgment, I'll place that a custom broker need not visit the premises of the importer. He needs to verify their authenticity from reliable documents.
Very well. So this is towards that.
Towards that, Your Lordship, just quickly, I will just indicate what are the documents. Import-export code, bank certificate. Thereafter, Your Lordship, at page 93 is the registration under Goods and Service Tax Act, GST registration. Then the Aadhaar and PAN card of the directors is from 94 onwards, Your Lordship. Now, Your Lordship, this was a private limited company. So at page 100 is the registration under the Ministry of Corporate Affairs, Your Lordship. The name of director is also given. Next page, Your Lordship, 101 is the registration with Director General of Foreign Trade, Your Lordship. certificate
So till 106, these are all documents towards KYC.
Your Lordship, yes. And Your Lordship, DGFT is the Director General of Foreign Trade who permits them to carry import-export. Now, Your Lordship, the goods were delivered by me to a
Why
person.
are you showing this? Has your identity been disputed? No.
Your Lordship, because they are saying that chat never verified the KYC of the actual importer. So, Your Lordship, in my reply, I specifically said that I have verified the KYC and I have also annexed the KYC. And now, Your Lordship, with this point comes, Your Lordship, in my, Your Lordship, if Your Lordship comes to page 240.
Page 240.
Your Lordship.
Yes.
Your Lordship, Your Lordship, here, just above point B, they are saying, hence the onus of physical verification of importer lies with Ashok Chando, custom broker, and none other. So, Your Lordship, they are casting on me an obligation of physical verification of importer, which is not there in the law. And Your Lordship, the division pen judgment of this Honorable Court, Your Lordship. Your Lordship has held that this obligation cannot be cast on a custom broker. This judgment, Your Lordship, may I hand over? Your Lordship, it's an unreported judgment. Your Lordship, in the case of Commissioner of Customs versus Sun Glory, Your Lordship. Your Lordship, if Your Lordship comes to page 5 directly, Your Lordship. Your Lordship, here the court has upheld the tribunal's finding that it is not the obligation
Paragraph.
Your Lordship, it is there's no paragraph number. Page 5, Your Lordship, paragraph, second paragraph.
Page 5.
The learned tribunal noted it will be extremely difficult, if not totally impossible, for the custom broker to physically visit the premises of each of its clients for verification. The tribunal also held that the regulation gives the option of verifying using documents data, and if there are authentic, independent and reliable document or data or information to show that the client is functioning at the declared address, the obligation on the part of the custom broker is fulfilled. Furthermore, the document which have been issued by various authorities of the central government has not been shown to be either fake or forged. Therefore, the tribunal concluded that there was no reason for the custom broker to doubt the authenticity of those documents or doubt the reliability of those documents. Your Lordship, may I also place the regulation under the Custom Broker Act? A regulation that I am just required to verify the documents, Your Lordship. N. N, Your Lordship, on the right side.
Customs broking license. N.
N, Your Lordship. That
Yes.
So, Your Lordship, this finding is also perverse, that I was required to, or I have not verified the physical existence. The finding that KYC was not checked is also perverse.
By using reliable, independent, authentic documents, data or information. So no physical verification
Is required, Your Lordship. So, Your Lordship, when they cast this obligation on me, Your Lordship, this itself is perverse, Your Lordship. Now, Your Lordship, Third point, Your Lordship, valuation. Here, what had happened, Your Lordship, certain stone at that period, Your Lordship, stones were being regularly imported. They were being 100% examined by the customs. Income tax approved value. Your Lordship, I will just show that in this case, there are 4 valuers, Your Lordship. All the valuers are government impaneled valuers. So, Your Lordship, if Your Lordship takes page 260, Your Lordship. Your Lordship. Volume 2, Your Lordship.
Yes. Bill of entry page double.
This is the examination order.
No, no, the bill of entry, the bill of entry. The bill of entry.
Bill of entry. Your Lordship, this document is a part of the bill of entry, Your Lordship, examination order. So, Your Lordship, from here,
This is the direction given by the group appraiser.
this is the Your Lordship, direction given by the group appraiser, who's a custom officer, to the concerned officer when the consignment arrived. Your Lordship, the instruction is open the package for 100% AP examination, Your Lordship.
Where are you reading, ma'am?
260, Your Lordship.
Page 260, yes.
Your Lordship, the middle paragraph.
Yes.
Examination order. Follow
targeters
yes, Your Lordship. Intervener
instructions. Yes.
Yes, Your Lordship. And open the package for 100% examination. In presence of government approved jewelry expert. Checked declaration with import documents. Government approved gem jeweler, Your Lordship. And Your Lordship, to ensure the facts have been checked and reported by the government draw representative sample.
So this is an order for examination, to be done in a particular way.
Your Lordship. Here,
which
Your
has
Lordship.
been mentioned. Yes.
In the valuation rules, Your Lordship, the broker has no role in valuation. Your Lordship, this is one part, Your Lordship. Other than that, Your Lordship, page 163, Your Lordship will find it's a part of the show cause notice, Your Lordship. At 163, Your Lordship. Your Lordship, in table B, Your Lordship, the second last column is government valuers.
Yes.
Your Lordship would see there is no one valuer, Your Lordship. There are 4 valuers. Your Lordship, in table 1, the 2 names are mentioned. In total 7 consignment, Your Lordship. Your Lordship will find that there are 4 valuers. There are 2 names mentioned in table 1 and 2 in table 2. And Your Lordship, they are government registered, Your Lordship, government approved. Their licenses, their certificates are at page 111. To show that these are not my chosen valuers, I may have appointed them on the instruction of the importer's representative, but they are the valuers who have been certified by the government, Your Lordship. Your Lordship, at page 111, 120, 147 and 151, Your Lordship. Their licenses are given, Your Lordship. Their certificate of empanelment with the government is there. And Your Lordship, this list is maintained by the customs and they only give the name to the importers or their representative as and when required.
Yes.
Now, Your Lordship, at page 241, Your Lordship. Sorry, Your Lordship, at page 240. I'm sorry, Your Lordship. This point is there, Your Lordship. Regarding arranging page 240, Your Lordship. Your Lordship.
Yes.
Your Lordship, in my reply, I have taken this point, which they have dealt with in point number B. which is the second last para at page 240.
Yes.
Regarding arranging government approved valuer, group appraisers gave list of valuers impaneled by income tax department. Accordingly, he contacted valuer from that list. I find that there are corroborative evidence in the form of examination orders, statement of not only the government approved valuer, but also the statement of Sri Ashok Kumar Chondo, partner of Chatterjee and Company, wherein they have admitted that government approved valuer was chosen and appointed by them only. So, Your Lordship, I may have appointed them from the list provided by the department, but Your Lordship, there is nothing, there is no admission by me that I had any knowledge of overvaluation or I participated in the whole whole transaction of a whole act of overvaluation, Your Lordship. Now, Your Lordship, next page. Custom, Your Lordship, my role, I'm a custom broker. My role is just on the basis of the invoices, Your Lordship, to file bill of entry.
Yes.
Your Lordship, next page. Custom had further enhanced the CIF value by 8% to the value given by the valuer.
Yes.
These government approved valuers are also notices. Notice, Your Lordship, here, but there's a judgment, Your Lordship. I'll just cite that first, Your Lordship. That when the valuer has given a valuation and if the customs have further enhanced, then custom broker cannot be held liable for that, Your Lordship. Just, Your Lordship. Your Lordship, this is division bench of our High Court, Your Lordship. 2023 386 ELT, page 253, Calcutta, Your Lordship.
Paragraph?
Paragraph, Your Lordship, 6 onwards, Your Lordship. Your Lordship, here the proceeding is under CBLR, but Your Lordship, the finding is the same. Your Lordship, may I place it, Your Lordship?
What is CBLR?
Your Lordship, the regulation, custom broker licensing regulation.
And this proceeding is under what?
Your Lordship, this is because they have imposed penalty on me, Your Lordship, under Customs Act, Your Lordship. Along with the importer, Your Lordship, they have imposed penalty on me, Your Lordship, saying that I have abetted this offense. But Your Lordship, that is also, Your Lordship, settled that unless they can show that I had specific knowledge or intention or any connivance, Your Lordship, they have just vaguely said that for money or extra money gain. That is not enough. They have to show that, Your Lordship, the goods have already arrived when my role to file bill of entry comes. Your Lordship, the finding is in the next page, Your Lordship.
I found it.
Your Lordship.
Therefore, the tribunal came to the conclusion that in the background of those facts, customs broker cannot be held guilty for not being able to find out the correct value of goods.
Your Lordship. Your Lordship, here there are 2 points, Your Lordship. Your Lordship, first point is this point that once the value has been given, value given in the bill of entry was enhanced by the approved valuer, further enhancement by the assessing officer of the custom department, then custom broker cannot be held guilty. Your Lordship, the second point which I said that
Physically verified.
physically verified.
Seen that.
Both is there, Your Lordship. Grateful, Your Lordship. No, Your Lordship, there is also a circular that custom broker, Your Lordship, should not be implicated under the proceeding under Customs Act in a routine manner. Unless, Your Lordship, there is a specific evidence of abatement. Your Lordship, this is routinely happening, Your Lordship. Custom brokers, Your Lordship, are service providers, Your Lordship. And it is routinely happening that along with the importers, exporters, they are also implicated and huge penalty is being imposed on them. That's why, Your Lordship, this circular has circular has come, Your Lordship. Circular, Your Lordship.
Yes.
Paragraph 4, Your Lordship. Accordingly, implicating custom broker as co-noticee in a routine manner in matter.
Unless abatement is established in investigation.
Your Lordship. But Your Lordship, what we are seeing in routine manner in every case, Your Lordship, they are making custom brokers a party and huge penalty is being imposed on them.
Yes. Yes, madam.
Your Lordship, there are two more judgments on the point that valuation is not the domain of the custom broker, Your Lordship.
You can give it. No need to read it.
Yes. Your Lordship, I'll hand over, Your Lordship, subsequently just.
Not a problem. Yes. Next point.
Yes, Your Lordship. Next point, Your Lordship. Your Lordship, there is a finding that I incurred expense on behalf of the customer. Your Lordship, again, Your Lordship, the entire finding against me is restricted in 3 pages. At page 239, 240, 240. So, Your Lordship, there is a finding that at page. There's a finding, Your Lordship, that I have paid money at page 239.2, Your Lordship. Your Lordship, in one they say, Your Lordship, they are saying that I am a part of in paragraph 9.3, Your Lordship, they are saying that I am a part of the conspiracy. And why I am the part of the conspiracy, Your Lordship, in the subsequent paragraphs they have explained. They themselves appointed the government approved valuer directly under the instruction of Saurabh Johari. Your Lordship, this Saurabh Johari was the representative of the importer. He was giving us all documents and instructions. So, Your Lordship, on his instruction, we have appointed and would then collect the bills from the valuers with details of their charges and would send them to Saurabh Johari for payment. Next paragraph, they used to get the valuers' charges directly from Saurabh Johari in cash, and thereafter they used to pay the valuers on behalf of the importer through RTGS. Your Lordship, cash always does not mean unaccounted money. I received from the importer's representative and paid. Now, Your Lordship, this is a trade practice which, Your Lordship, I will show from a government circular, Your Lordship. Your Lordship, there is a circular.
Yes.
Of under service tax law, Your Lordship. Your Lordship, I'll give it to my learned friend. Just paragraph. I'll just read and place it and hand it over, Your Lordship. Paragraph 2, Your Lordship. Your Lordship, while the principal job of the CHA, Your Lordship, custom broker was previously known as custom house agent.
I've read it. I've read it. Thank you.
Your Lordship. Your Lordship,
they will first pay and they will.
Your Lordship, they arrange various services, and Your Lordship, they make payment on behalf. Your Lordship, it is very difficult for others to believe that, Your Lordship, a lawyer can be paid at the end of the year and they incur expense from their pocket. But Your Lordship, these are trade practices, Your Lordship. And this is now, Your Lordship, documented in a circular of service tax. So, Your Lordship, this cannot be a premise to hold that I have connived. So, Your Lordship, next paragraph, the importers, point 3, in respect of importers represented by Saurabh Johari, Shri Sanjay Chaudhary used to take delivery of precious semi-stones from them. Sanjay Chaudhary was introduced to them by Saurabh Johari. Your Lordship, the importer had introduced this person. After clearance, the goods were handed over to Sri Saurabh Johari through his agent. They used to prepare road challan for delivery of the consignment to the party's representative, Sanjay Johari. And Mr. Sanjay Johari used to collect the consignment for all the parties. They did not. Your Lordship. This also, Your Lordship. There is a specific, Your Lordship, I have a sister concern. In favor of that sister concern, Your Lordship, the importer had given a instruction that I should give the documents to Saurabh Johari, which is at page 105, Your Lordship.
105.
105. And Your Lordship, under the Customs Act, Your Lordship, the declaration about the correctness of the, Your Lordship, valuation, etc., is given by the importer, which is at page 127.
So what is the relevance of this document at page 105?
105, Your Lordship, that I have not handed over to, because I was in conspiracy with this person. I have handed over because that was the instruction to me from the importer or the representative of the importer, Your Lordship.
No, but this Gauri Trading Private Limited is not
Is the importer.
It is the importer.
Your Lordship. And Your Lordship, the name, Your Lordship, of the 105, Your Lordship, is my sister concern, Your Lordship, Seaving International Co.
So this Gauri Trading was so long being represented by Saurabh Johari and Sanjay Chaudhary.
Yeah, Saurabh Johari, yes, Your Lordship. And he instructed us that give the delivery to Sanjay Chaudhary.
Okay.
130.
Statement.
Yes.
Your Lordship, there is a finding which I had placed earlier also. Your Lordship, first, Your Lordship, should I complete the, Your Lordship, I was reading from page 239.
I have read it.
Your Lordship.
Not required.
So, Your Lordship, there is a finding at page 240, Your Lordship, in point B, under point B, the last paragraph. I find that there are corroborative evidence in the form of examination orders. Your Lordship, one of the examination order, Your Lordship, I had statements of not only government approved valuer, but also the statement of Ashok Chaudhary. So, Your Lordship, in my statement, I have nowhere said that I had knowledge of
Yes, you said that there is no admission of overvaluation, no admission of participation in the process of
Your Lordship. Now, Your Lordship, the second part is not only from the statement of government approved valuer. So, Your Lordship, none of the valuer have said anything against me. Your Lordship, the only thing which I could find, Your Lordship, my statement is recorded in page 166, Your Lordship, of the order in volume 2, part of the order. There is another statement by Saurabh Johari, Your Lordship, which is at page 72. He says that he has knowingly indulged as himself in such activities for his benefactors. That is at page 72, Your Lordship. But he has not said that he had informed me of misdeclaration or I had any knowledge. Now, Your Lordship, next at page 174. Your Lordship, the statement of Saurabh Johari starts at page 170. I was placing page 172, the last point, Roman 9, where he says,
he admitted that he has knowingly indulged in activities of benefit.
Your Lordship. Next, Your Lordship, at page 174.
Page 174.
Your Lordship, there is a statement, the excerpt of statement of Sri Amit Bhotoria. He was one of the valuer, Your Lordship. In point 3, they are saying that he has purportedly, Your Lordship, he knew that the import consignment were highly overvalued, but he was asked to give valuation certificate as per invoices of overseas supplier against extra money consideration. But Your Lordship, I have gone through his statement, Your Lordship, which was given to me. There are 3 pages missing, Your Lordship. And Your Lordship, this point was taken by the advocate for Amit Guturia at the relevant time. He was provided those 3 pages, but Your Lordship, I was not there at that time. So Your Lordship, I don't have those 3 pages, but there is nothing in his statement against me. And Your Lordship, in my statement also, Your Lordship, there is nothing against me. If Your Lordship desires, I can give the statement which has been
That
given
will be
to
going too much on facts.
But Your Lordship, there is nothing, because Your Lordship, I'm saying it's perverse. This is not his statement. This is an excerpt of his statement, which they have quoted, and this is not there anywhere, Your Lordship. And Your Lordship, this
anything
does
on
not
the,
even
anything on the jurisdictional aspect? He
Your
had
Lordship,
jurisdiction to
jurisdictional
defend.
aspect on this also, Your Lordship. If they are saying that from my statement and the statement of the valuer, then Your Lordship, they have to give me the right of cross-examination of these valuers. And Your Lordship, before they make any of the statement of the valuers a part of the adjudication order, they have to prove the statement, Your Lordship, in terms of section 138B. Your Lordship, the act is before with Your Lordship. Section 138B, Your Lordship.
So statements of valuers and all were never supplied to you.
Your Lordship, the statements have to be proved by.
So were they supplied to you or not? They were supplied.
Your Lordship, except they supplied us in a CD format, Your Lordship. So Your Lordship, when I saw the when I went through the statement, Your Lordship, there were 3 pages missing in this statement.
No, they were supplied at the writ stage or they were supplied earlier.
This was initially only supplied, Your Lordship. There are.
So you had knowledge of these statements.
There's nothing against me in this statement, Your Lordship. I've gone through the.
So therefore, did you ask for cross examination?
Your Lordship, there is no need. Your Lordship,
so since you are making a point that
Your Lordship, I will
explain not to have
Your Lordship, the statement has to be proved in terms of 138B. So Your Lordship, the requirement of asking also doesn't arise. If the statement is not proved under 138B, it can be used for investigation purpose, but it cannot be used for adjudication purpose, Your Lordship. Your Lordship, as it is the statement which they have quoted as excerpt, does not clearly indict me. He does not say that I paid him money or I offered him extra consideration, nor there is any proof or evidence of extra consideration, Your Lordship. So, Your Lordship, this is as it is vague. And Your Lordship, in the finding also they say that from the statements, from whose statement they don't say. It is as it is vague, Your Lordship. It is not enough to call me an abettor. Those judgments are there, Your Lordship, that knowledge, intention, if I am unknowingly even furthering their cause by filing the bill of entry, that does not make me an abettor. Your Lordship, again, Your Lordship, the principles of criminal law has been brought in here.
Yes, that's all.
138B, Your Lordship, I'll just.
I've read it. Relevancy, I've read it.
Your Lordship, just wanted to place it once, Your Lordship. A statement made and signed by a person before the gazetted officer of the custom during the course of inquiry proceeding under this act shall be relevant for the purpose of proving in any prosecution. Your Lordship, for the purpose of proving in any prosecution for an offense under this act, the truth of the facts which it contains. When the person who made the statement is dead or not found.
This is relevant for prosecution. This is not one.
This is also prosecution under this act, Your Lordship. Penalty has been imposed.
Penalty in prosecution will be before courts. It can't be before the authority.
Your Lordship, this is also prosecution, Your Lordship.
They are also prosecuted under.
Has it been defined that in some way where,
I will again have to revisit. But Your Lordship, I have judgments that these statements, if they want to use it in against me in adjudication, they have to first comply
the same
with
standard of proof will apply.
Your Lordship. Your Lordship, I'm coming to B. When the person who has made the statement is examined as a witness in the case before the court, and the court is of the opinion that having regard to the circumstances of the case, the statement should be admitted in evidence in the interest of justice. And Your Lordship, the subsection 2 is also important. The provision of subsection 1 shall, so far as may be, apply in relation to any proceeding under this Act, other than proceeding before a court, as they apply in relation to a proceeding. So, Your Lordship, this is the matter. Your Lordship, may I place the judgments on this 138B, Your Lordship? Your Lordship, today we are at a motion stage, Your Lordship. I don't know whether my learned friend will ask for affidavits, Your Lordship.
Yes, Mr. Bhattacharya.
Your Lordship, there are several other. I will give Your Lordship.
That apartment, that order passed in which we find the requisite. The appeal period has
Expired.
There is no
Yes, ma'am, that's a solid.
Your Lordship, that I have, Your Lordship, there are, Your Lordship, 6 cases against me between 22 to 21 to 25 under this Customs
But
Act.
if an order has been passed in 2022 and there is a remedy before the appellate authority, maybe you are not able to file the appeal
Your Lordship,
because of the pre-deposit factor.
Your Lordship,
You are not prevented from approaching the writ court within
Your
the same
Lordship,
time.
here the proceeding was initiated against me under the Custom Broker License Regulation. 2 cases. One, I have been exonerated for suspension. For revocation, Your Lordship, it is still pending. Secondly, Your Lordship, there was a criminal case, Your Lordship, against me, which they initiated in
But
2019.
that does not exonerate you from this.
Your Lordship, I'm coming to all the. Your Lordship,
No,
what
but this
caused
point you have to, because
this on
this
this
point
point?
was taken at the threshold, I would not have wasted this.
Your Lordship, I had pointed out yesterday also, Your Lordship. I will
I
explain.
won't remember.
On delay only, Your Lordship, I will again. Your Lordship, this is all part of. Your Lordship, I was embroiled in
First
so many.
explain delay.
This delay,
Where
Your
is-
Lordship.
How have you explained it in the writ?
Your Lordship, page 31, Your Lordship.
Page 31.
Your Lordship, second paragraph at page 31. The petitioner number 2 is the main working partner of the petitioner number 1. The other partner, Your Lordship, there is only one partner who is the brother. The wife of the petitioner number 2 is the cancer patient and heart patient, Your Lordship. Your Lordship, I have annexed documents that the petitioner number 2 is the sole caregiver. After passing the impugn order, the original petitioner number 2 got caught up in the treatment of his wife. The petitioners as such could not prefer the statutory appeal from the said order in original within the stipulated or extended time. Copies of the medical documents are there, Your Lordship. I place the documents, Your Lordship. Thereafter, Your Lordship, my license was also suspended. I was under extreme financial crunch, Your Lordship. I've annexed the bank statement, etc. I am also carrying the balance sheet. Your Lordship, this matter was also before the erstwhile bench also, Your Lordship. His Lordship was of the view that I should deposit some money. And then, Your Lordship, I told him that my financial condition is bad, Your Lordship. Then he said, okay, bring your bank statement or you come with money. So, Your Lordship, I was carrying the bank statement, Your Lordship.
Yes, Mr. Bhattacharya.
Your Lordship.
There is no explanation at all.
May,
My landlord is arguing the matter like him alone that an appeal to the court. My lord, error apparent even if for the sake of I am not admitting error apparent on the face of the order matter that is appealable. That cannot be corrected, my lord.
That is not a correction of natural
For the court in sitting in
over an appeal.
And my lord, license suspended in 2019. 2022 order was passed. Therefore, the explanation is nothing like the big explanation. And therefore, why he has delayed for a period of 3 years, my lord, that has not been extended. And my lord, what my lord is saying, my lord, everything has been dealt with. Well, I've got a larger based decision that in a given case, my lord, the partner is also liable. That case I have. I don't want I just now, but I must say, my lord.
No, if you have it, please give it to me.
First, my lord, 2016. That I yes, rather than that. And my lord, I'm admitting, I am not admitting that there is any illegal at all in the order. But if I place the order, my lord, I show that we, my lord, in conspiracy and connivance with this, my lord, in supporting this, my lord, precious stones. And my lord, on verification, it appears that there is no existence of that imported. It did not also verify the, my lord, KYC. The order is the, my lord, there is as many as your lord, the right from starts from 162 onward up to 256. Large judgment has been given by the, my lord. I am Mr. Lord can allow to place, my lord, that you lord how it has been dealt by there. And there is, my lord, no violation of principle of natural justice. No lack of jurisdiction. And therefore, my lord,
Not amenable to read at all.
and also it is not amenable to read. You have to satisfy the ingredients that is done by the court.
Radhakrishna Industries and
Radhakrishna Industries, they were good.
and Bhagat Sugar.
And also I will bring Bhagat Sugar's case. Where the Supreme Court has decided what the points to be considered in court.
In case there is applicable member.
Since there is applicable remedy, that judgment you want to place. Thereafter I place the ordinary. Ordinary speaks of the about that.
When should I keep it? When should I keep it?
First, we have to supply the judgments.
Judgments.
Your Lordship, the ones which I have, we can exchange the judgments, Your Lordship. And Your Lordship, on the delay, Your Lordship, may I place the documents, Your Lordship, which I'm
Show me
saying
the documents
fitment.
once.
Your Lordship. Your
Because
Lordship,
delay is substantial. 3
Your Lordship,
years.
3 years. But Your Lordship, if Your Lordship sees there's one order which is passed in 25. Your Lordship, when the
That is,
yes.
that is consequential.
Out of the 6 writ petition, Your Lordship, one of the orders is passed in 25.
Very well.
And
so far as the others are
others are concerned, Your Lordship, the petitioner, Your Lordship, if there was a criminal case which has been dropped against me, Your Lordship, in 23. From the same facts, Your Lordship, this case was initiated by DRI, Your Lordship. DRI initiated criminal case against me, Your Lordship, which they have dropped. Your Lordship, may I just place it, Your Lordship, at page, Your Lordship, 361, Your Lordship. At 362, Your Lordship. Your Lordship, I am coming. Your Lordship,
the statute does not, but import.
Your Lordship, I should get a chance. I will just explain it, Your Lordship. Your Lordship.
Very well. Today, we'll not. Others are also waiting at this point. Since it is not going to conclude today.
Your Lordship.
When next?
Your Lordship, on delay, Your Lordship, first.
On the next day. We'll be having a second round.
Your Lordship.
My lord, if your
so that I can touch up other matters also.
Your Lordship takes up 26, man. 26.
26th.
Your Lordship. Your Lordship, Your Lordship, Your Lordship, there is a delay slightly more than 3 years in this petition, Your Lordship. But Your Lordship, if a person
in
is
the others also 3 years.
Your Lordship, in 4 matters, yes, Your Lordship. In 5th matter, Your Lordship, it's a recent.
Difficult.
Your Lordship, the facts are, Your Lordship.
You place it. Likun.
My lord, one paragraph I want to place my judgment from my judgment, my lord.
Later. Heard learned advocate. এই বইটা on।
Your Lordship, all the matters, 6 matters.
My lord, maintainability point should be kept open, my
All
lord.
the others I'm not passing any
Your
order.
Lordship.
They'll appear on 26th, the others.
Well, only one sentence, if you will say, admiral, maintainability point has been raised in this.
Yes.
Kindly, my lord.
তো লিখে দিন ঠিক এর লাস্টের উপরে
My lord, kindly have a look. The synopsis, kindly have a first look to the synopsis, my lord, of the.
What is the
read
subject
petition.
matter of challenge?
My lord, my lord, the show cause notice has not been issued within the period of 6 months, so goods should be returned to the petitioners. Well, kindly take this compilation.
Well, 110 subsection 2 kindly sees custom section, my lord.
Well,
I will cut short the matter, my lord. We
Our-
have
our
obtained the
case would
extension.
now-
We have obtained the extension, my lord. We have the
Our
document. I
case-
can show before lordship just now. Need
আমার
not to,
কেস আমাকে প্লেস করতে দেবে
need
না।
not to, my lord, elaborate anything.
আরে আমার কেস let me place my case. My lord, 18/1/2024. Customs officer came to the shop, conducted search, seizure, and he was brought to the customs house where Panchnama was prepared showing seizure of gold of Indian origin and 2 pieces weighing such and such grams and cash rupees such and such. My lord, the 6 months was expired on 17th of July 2025. 6 months. My lord, show cause notice 5/8/2024. Show cause notice was dispatched, which was received on 7/8/2024. The show cause notice was not issued and received by the petitioner within the stipulated time of 6 months. It was 20 days delay, and as such, the petitioner is entitled to get return of the seized gold and the cash
Yes,
as
Mr.
per
Mullah, I have
Panchnama.
gone through it.
My lord,
You see the proviso, first proviso to section 110, subsection 2. Now, if the principal commissioner of customs or the commissioner of customs has extended the period, then
yes, it has not been extended.
he's submitting it has been.
It has not been extended.
He's submitting it has been.
My lord, let them.
The letter was received by my learned friend's client here. My lord, I have a single copy.
Where, which letter? My lord, kindly see. দাঁড়াও না, আমাকে এখানে বলতে দাও। My lord, kindly come at page 8 of the read petition. Page 9, paragraph 13. That a notice of hearing was given to the petitioner asking to attend on 24th on 22nd of April 2025.
No, 10th of July 2024, writ petitioner has received this letter. 10th of July of extension of time in terms of section 110.
Well, according to that, has not been received. Well,
No,
kindly,
but then
kindly direct them to serve a letter to me, my lord. And check. If possible, my lord, kindly direct affidavit, short affidavit
challenge the validity of 148 proceedings. And my learned friend Mr. Amit Sharma is appearing for the department.
Yes,
He told
was
me
there yesterday.
he's presently on his legs in courtroom number 15. He informed me.
Oh. So yesterday you didn't appear, today he is not.
Yes, we apologize, Your Lordship, for the inconvenience.
So what should I do? Not today.
If it may be convenient, my lord, not today. Tuesday, if it may be fixed, my lord.
लिखे नहीं? Now, although the petitioner is represented through Mr. Jhunjhunwala, the petitioner is represented through Mr. Jhunjhunwala, full stop. Time is great for I don't know 17.
We'll, give them one more notice. They were not there yesterday.
All right. None appears for the respondents. None appears for the respondents.
Lordship, item number 18, Lordship. We're appearing on instructions, Lordship. This item was taken up yesterday. Your Lordship was pleased to fix this matter on the 21st November. It has come up in the list wrongly. Grateful, Lordship.
Item number 19.
Same for 19.
The আগের অর্ডারটা করে দিন সার্ভিস অফ নোটিস যেটা
My lord, in item number 19, I am appearing for the respondents, my lord.
Yes, madam, you are inaudible.
In item number 19, I am for the respondent, my lord.
You are appearing, but you
My
are
lord, I am praying for not today. Lord,
Any day, Your Lordship.
not today, my lord.
অনলাইনে খুব অসুবিধা হয় কিছু বোঝা যায় না লিখে নিন although the respondent is represented but due to network issues she is inaudible, full stop. List this matter on November 18. November 18th November. Please be physically present because online it is not helping. We are not able to make out anything of what you are submitting, ma'am. You are not audible at all.
I'm appearing for. Your Lordship, here we have come up against the appellate order GST, where Your Lordship, initially the penalty has been levied and thereafter it has been confirmed by the appellate authority. My only short point, Your Lordship, is
that here they have completed the entire procedure within the course of the day. No show cause notice has ever been served upon me, and I have not been given an opportunity of hearing where section 129 subsection 4 mandates that before imposition of penalty. I can show from the records, Your Lordship, the day where the detention order has been passed, that very same day, Your Lordship, the final order has been passed, wherein it has been recorded that we have not come forward and given the reply. We have not received any show cause notice, and even, Your Lordship, for a minute, if I may assume that show cause notice was given to me, how can the final order be passed on the very same day?
Yes, Mr. Sanyal.
Lordship, order
May-
of detention says something else. Page 55, Your Lordship.
Page 55.
55.
Page 55. Yes.
Page
Last
54 is the order of detention, Your Lordship.
Page
Page
55.
55 is the final order, is one of the order where I have received only one page, page 3. Page 54 is the detention order, Your Lordship. It is stated also, order of detention.
Kindly, Lordship, last paragraph.
Last paragraph.
After receiving the show cause notice in form GST MOF 7, the owner of the goods did not file any objection against the
Last
show cause
paragraph at page 54.
55, Your Lordship. That 54 is the form, Your Lordship.
55. Last
It's
paragraph.
the order.
After receiving show cause notice in such and such the owner of the goods. How did you serve the show cause notice?
Lordship is done through the
Because
portal
her
itself.
contention is that show cause notice was never served.
But it's done through portal itself, Your Lordship. Those are my instructions, Lordship.
It is not. I will play, Your Lordship, page 54 if Your
Because
Lordship
everything
takes.
has to be in the portal, Your Lordship.
Very well. Let me just give page 54 if Your Lordship takes.
Page
That is the detention order. Page 55 is a different order, Your Lordship. Your Lordship sees page 54, it ends. It is MOV 06. And Your Lordship, page 55 is MOV 09, where Your Lordship, that is also one of the contention, that where I have received only an order in the white sheet, page 3. They are different documents. And it is the entire proceeding has been completed. Your
Page, where did you read MOV 09?
Yes, Your Lordship, it is not stated that from the portal I found. This is my this is, I've stated in the appellate grounds of appeal. This is what has come up in the portal. I have not received MOV 07, which is the show cause notice. And all of these orders, Your Lordship, are dated same. Even if they have given me, how can Your Lordship will kindly see that
If
31st.
it is served on the portal, how can that be proved that it has been served on the portal? Something from the portal.
Lordship kindly comes to page 38 then, because 38 shows, because a MOV 9 is supposed to be DRC 07. 39 is the
38.
No, MOV 9 is not
DRC 07.
DRC 07. MOV 07 is the show cause notice, which we have not received.
And
Which we have not received.
DRC 07, page 39. This they have received, this is the final order, Your Lordship.
Yes, but this should be preceded by the show cause notice.
It has to be preceded by the
Where
show
is
cause
that?
notice. Lordship have to take instruction whether show cause notice has been specific instruction that
Because it's not served, it's gone.
because here it says show cause notice has been they are saying show cause, but
It
have
is
to take instruction whether it's uploaded
No,
in
but
the
it
portal.
doesn't appear to be, because this order there is something which pricks. Page 54 and page 55. Page
Same date.
55 does not appear to be in continuation of
Yes, I am
page 54.
deeply obliged.
Because
That is
MOV
MOV
6, MOV 7, then MOV 6, then MOV 9. MOV 9 is the final order.
Very well. So MOV 7 will precede MOV 6.
MOV 7 will precede, MOV
7
7 is the show cause notice.
Yes, Your Lordship.
It's the show cause
And
notice.
MOV 6 is the order.
No,
MOV
MOV
6
6 is detention
is the
order.
detention
MOV
order.
9 is the final
Final
order.
order.
Acha.
So MOV 7 will precede
And
MOV
MOV
9.
9
This
is
page
30.
55 is
MOV 6
nothing.
is the detention order. And MOV 9 is the 38, page 38.
MOV, Your Lordship, if I may say, page 54 is MOV 6. And page 55 is only the last page of MOV 9, which is the final order.
But DRC 7,
And
page
Your Lordship,
30.
I have received only the last.
And where are the preceding pages then? They have not been served.
Page 39 is showing something else. Page 39. I will take on, okay, Your Lordship, I will take instead, but page 39 is DRC 07.
Yes, that
DRC 07 is
that is MOV 9.
But
That
this
is the MOV 9. Supposed to be the MOV 9. This is the DRC 07 is the MOV 9.
DRC 07 and MOB 9 are the same
Are
thing.
the same.
No, no, DRC 07 is the
Is the
summary.
summary.
Summary, but the
Nomenclature.
but the
And MOB
main
9 is the detailed.
yes,
Is a detailed order.
and we have received only the last page.
I'll take instruction, Your Lordship.
And where is MOB 7, Your Lordship? It is not uploaded in the portal. And they record that we have not.
Total mess of
I
everything.
I will come back with all the orders separately. Your
The petitioner says
Milord, I am appearing for the petitioner. Milord, I am happy to have an opportunity to appear before. It's a claim of refund, Milord, of a fringe benefit tax. Order was passed accepting my claim, and even interest was allowed, but they don't pay the money. When I insist upon, they pass an order in April 25 without hearing, without notice anything, rejecting the whole thing. My lord, that is the in fundamental.
yes,
that is
Mr. Bhattacharya.
the order is at page.
But in this case, my lord, I have to take some instruction because, my lord, your lordship kindly see.
Page 96 is the.
From the, my lord, there are several assessment here is involved, my lord. Order has been passed, similar order has been passed. Now, my lord, I am placing the last order, page 123.
Page
123.
Judge's copy.
123.
Judge's copy though.
Now, lord,
My lord, may I give a list of dates and its synopsis so that with the page numbers and all mentioned there.
but that is, my lord, from, my lord, page 123, but it is appearing, my lord, 2006-7 advance tax paid on account of fringe benefit tax, my lord, 17 lakhs. My lord, your lordship got bottom portion, my lord.
Yes.
Serial number 1, assessment year 2006-7.
Yes.
The advance tax paid on account of FBT 17,60,000. The claim of the assessee to release the refund along with interest 37 lakhs. Nominal value of fringe benefit disclosed by the assessee nil. Now, what I understand, I have to take instruction in this matter also, because it also says in the second page there is another writ petition filed by the assessee. Your lordship kindly turn to the next page. Writ petition number 1902 of 2005. that has been dismissed on 3rd April 2014, and thereafter assessees claim that after 8 years, assessee has knowledge of that dismissal of the writ petition. Now here the case is that why what I understand, fringe benefit is a benefit, it was operating from 2006 to 2010. Now this is a benefit given by the employer to the employee. Now these benefits, suppose house rent or something like that. Now the employer deducted the tax, 30% deducted the tax, and employer paid to the department. Now here the case is that the advance tax paid by the employer in the year of 2006-7, 17 lakhs. But surprisingly, the value of fringe benefit disclosed by the assessee nil. Now if the employer says the value of fringe benefit nil, and he has paid huge amount of advance tax for all the assessment years, it is very much surprising. But I have to take instruction regarding the writ petition filed by the assessee in the year of 2005.
Let my learned friend file an affidavit in opposition, my lord.
I will file.
My lord, let it be 4 weeks and 2 weeks after the vacation.
Very well. This writ petition, this writ petition has been filed